All right, I think we've got everything in place. Good afternoon, everyone. We have a jail Zoom calendar that is a mix of plea arraignment. I think we've got some bond hearings, or at least bench warrant set-asides, and a few probation revocation matters. And I think I have a list of where everyone is in terms of booths. And Ms. Smith, you're here, which is great. It's good to have one direct connection. Position one is Mr. Huey, and he should be 6 booth. Let's see if I can get things working. Hello, Mr. Melnick.
Hey, good afternoon, Your Honor.
Are you Mr. Huey?
Yes, sir.
Am I saying your name correctly?
Yes, sir.
All right. Ms. Nelson, do we know if Ms. Cabrera is joining us?
I'm reaching out to her right now, Judge. I'll check.
Okay. Mr. Huey, your case is on for plea and arraignment. You have had appointed for you our conflict defender. I guess you must have a co-defendant. There's some hiccup with your case so that the public defender doesn't represent you. And Ms. Cabrera, our conflict defender, is often stuck in other courtrooms. So we're going to try to track her down. I'm looking for your case. Nope. I wonder if it's your other case that has co-defendants. Nope. Ms. Wood or Ms. Rios, do you know why Ms. Cabrera is on the case?
I am not sure, Your Honor. We could do some research.
No, I mean, it's clearly Ms. Cabrera's case, although the other case lists a Justin Showalter as the lawyer. Is that someone from your office?
Judge, good afternoon, Judge. Sorry to butt in, but I had spoken to Mr. Haddad about these cases to confirm the conflicts. There are conflicts. I'm not remembering off the top of my head what they are. There's actually someone named Shawanda Brown who is assigned to that number 2 case. So I'm not sure if that's gonna flip over to Ms. Cabrera, but that's what I know.
Okay. All right. Well, Mr. Huey, I'm going to mute your microphone. Please don't go anywhere. We're going to figure out if we can track Ms. Cabrera down, but you've got 2 cases on for plea and arraignment. Both charge you with aggravated assault. Ms. Cabrera is assigned to one, and then Justin Showalter is assigned to the other. We just need one lawyer for you for your 2 cases, unless you've hired a lawyer for either one. Have you hired anyone?
No, sir.
Okay. Well, we'll get to the bottom of this and make sure we can move your case forward. But I'm going to ask you to sit tight, okay?
Okay.
Thanks. All right, that gets us to Bruce Ector. That's 4 North, booth 1. Hello, Mr. Ector. Can you hear me?
Yes, sir.
Good afternoon. I'm Judge McBurney. Your case has been assigned to my division. The lawyer representing you is Ms. Wood. You should be able to see her on the screen there. Ms. Wood, good afternoon.
Hello, Judge. This is a negotiated plea and we are ready to go when the court's ready.
Fantastic. Let me make that note here. Mr. Ector is a plea. Ms. Smith, your case? Okay. We will do that in just a little bit. We'll get through the calendar, figure out the plan. So Mr. Ector, I'm going to put you back on mute and then we'll bring you back up onto the screen when we are able to take your plea in a little bit, okay?
Okay.
Thanks. One. Who's representing Mr. Johnson, position 4?
He's mine, Judge.
Great. Let's get him on the screen.
And that's gonna be ADA Willingham, Your Honor.
There she is. All right, and let's get Mr. Johnson. He isn't on. We don't have a 3 North booth 1 on. Let me see if I can do something. Ms. Wood, while I'm trying to get a connection with that booth, what are we doing today with Mr. Johnson?
Just a waiver of arraignment, Judge. I've already filed the waiver and I also filed a speedy trial demand. We're already on the March calendar.
Oh, well, it's good that we meet Mr. Johnson then. Okay. Is this the gentleman who was in New York prison supposedly when things happened? Different client.
That's a different speedy, Judge.
It's hard to keep track of all your speedies. All right. Is there someone from the sheriff's team on the call? Ms. Nelson, if you wouldn't mind reaching out to someone, I cannot connect with 3 North booth 1, which is where Mr. Johnson supposedly is. So I'll need them to get into a different booth and maybe we can connect with that. All right, we'll come back to that. Mr. Price, I don't have a booth listed for Mr. Price. Rocky start here. Ms. Nelson, if you've got any information as to where position 5 is, that would be great.
Okay, just one moment, Judge.
Okay. Hey, Mr. Williams, you are on for bond reconsideration. We'll do that in a minute. I know Mr. Wallach is on as well. I'm just going to get through the calendar so we can figure out what we're doing and the order in which we're going to do it. So I will certainly hear from Mr. Wallach. Who's going to handle this for Ms. Nix? You are. Great. Okay. Thank you. And what about then if you are playing the role of Ms. Nix, Mr. Gamba Mateus?
I'll take that.
Is that going to be a plea?
Not from our knowledge, Your Honor.
Ms. Rios, what was the plan? You were saying something about the plan with Mr. Gamba Mateus. We do have
That it would be a plea, but I haven't been able to connect with someone in the AD's office who would talk to me about the case or an offer. I've been trying for a while. I do feel bad because he's been in for a while, and I wanted to get something resolved here. And I told him I would possibly be able to take a plea with him today, but unfortunately, Ms. Nix is on trial. And I thought by filing a bond motion, I do want to have the bond hearing still, but another point was to get someone's attention so we could talk about this case.
Okay. Well, you certainly got someone's attention because we've got a interpreter here, and we will talk about the bond reduction motion. And maybe there's a way, if we're focusing on something else, that Ms. Smith or Mr. Sperry could talk with you offline about something beyond just the bond reduction.
Yes, Your Honor. Thank you.
Okay. Tobias Slade. I don't have a location for Tobias Slade either. Well, we'll work on that. And I don't know where Leslie Cook is. Or Cordelius Sanders.
Your Honor, Ms. Cook is here at ACDC. Good afternoon.
Okay, who else do we have there?
I also have position 12, Mr. Richardson.
All right, excellent. So ACDC for Mr. Cook and for Mr. Richardson. All right. Who is handling Mr. Cook's revocation? Okay, and for the defense?
Your Honor, that will be me, but I will be asking for a reset because I reached out to drug court and he has a pending application with drug court. He also has some open unindicted cases that we're hoping to wrap all into drug court.
Okay. Mr. Cook, were you able to hear that?
I also, yeah, it was. I'm also a member of PAD. PAD was supposed to be there with somebody there today as well.
Okay. Well, there could be on the Zoom call someone from PAD, and I'm happy to hear from them. But I'll tell you, if we are looking at drug court, which would be a great opportunity for you, we're going to want to see if we can line that up and figure out which of your cases could get into drug court. Okay.
Yes, sir. I would. I really appreciate that. I need some help. I need y'all to help me.
Okay. Well, I'm going to work with Ms. Rios and Ms. Smith to figure out how soon we can get you back here. But we don't want to get you back here until we know what the answer is from drug court about whether they'll take you. Okay.
Yes, sir.
All right. You have any other questions for me?
Is there some kind of time frame I'm looking at before I can come see you again?
That's a great question. I would say a couple weeks. Ms. Rios, have you already done the referral to the accountability court?
Yes, they said he was referred and they're still in the screening process.
Okay. So Mr. Cook, it usually takes a couple weeks for the accountability court to determine your eligibility, which is driven partly by your needs. If all you do is smoke a joint once a month, you're not going into drug court. But if your addiction is stronger than that, then you'd be eligible. We also have to make sure there's nothing in your criminal history that would make you ineligible. So they're going to do that, and then we'll figure out the answer. So I would expect to see you in a couple weeks or so. And if the answer is you're in, then it sounds like at least the defense is going to recommend that's what we do with your revocation, and there may be some unindicted charges that get rolled into drug court as well, assuming you get accepted. But of course, I'll need to hear from the prosecution as well. It just doesn't make sense to have that conversation until we know if drug court is actually an option. Okay?
Yes, sir, Mr. McBurney. I appreciate you.
All right, you're good to go. Thank you.
Thank you.
How about Mr. Richardson, who is handling his revocation?
He's mine, Judge.
Okay. Is that a quick one or is that an involved one?
It's a quick one. It's just a non-negotiated stipulation.
Okay. Excellent. We will take care of that shortly. Jorge Rivera. I don't have a location for him. Another interpreter case. We got an interpreter for both our cases. Mr. Kimball, we do have a location for And then not for Brown. Okay. Ms. Wood, no, I think it'd be Ms. Rios. Ms. Rios, are you handling Kimball?
Sorry, I was on mute. Kimball is a conflict, Your Honor.
Okay. All right. So why don't I get him on the screen and take care of that? I can take care of Mr. Huey, and then we can cycle our way back through the calendar and knock some of these out. We do have some people we need to find. 3 North, Booth 2. Excellent. Let's see if we can connect to that. All right. Hey, are you Mr. Kimball?
Yes, sir.
Hey, I'm Judge McBurney. Your case has been assigned to my division, and you were picked up on a grand jury warrant. I'm going to pull up your case right now, and we need to get a conflict defender assigned to represent you because the district at the public defender's office has a conflict. They already represent someone in the case. So we need to get you your own independent attorney, and we will do that, and I'll get you back in here as quickly as we can make that assignment so that lawyer can talk with you and figure out what's next in your case. You got any questions about any of that?
Yes, sir. What does it require for bond?
It requires 2 things. 1, we got to get you a lawyer, and then 2, we need to have a hearing. But you are certainly entitled to that discussion. We just need a lawyer to represent you, to advocate for bond in your case. You currently have no bond because you were directly indicted. There was never a preliminary hearing or anything like that. And you were picked up on a grand jury warrant that I or some other judge signed. So you are definitely entitled to be heard on bail. We just need to get that lawyer in place so that she or he can make that argument. So when I see you next, not only will your lawyer be there, but what we'll talk about is bond. Okay?
Okay. Do you know about how long it'll be, sir?
I would think it would be a couple weeks-ish. We just need to contact that lawyer and then get this on a calendar so that the lawyer can be here. And then we'll have that conversation, all right?
Yes, sir.
All right, anything else?
No, sir.
All right, appreciate your patience. You're good to go for now. Case with her judging. Hey, Mr. Huey, I'm back. We have tracked down Ms. Cabrera. She's not going to be able to be here today. She actually had leave. I didn't realize that when we put this on the calendar. So we're going to, when she is back from her leave, get you here so that we can do arraignment on both your cases. And between now and then, we'll figure out if she can pick up your second case. Did you tell me, Ms. Wood, Showalter is someone from your office, or he is a conflict defender, but maybe from pre-indictment?
Judge, he's with our office, but there's someone named Shawanda Brown who this was appointed to out of conflict.
Oh,
He just hasn't filed an entry yet.
How do you know this?
Mr. Haddad.
Oh, okay. Interesting. I will write that name down and she and Ms. Cabrera should talk because I don't think we need both lawyers for Mr. Huey. Can you spell her first name?
SHAWONDA and then Brown, common spelling.
Got it. Thank you.
You got it.
So, Mr. Huey, we need to sort out which of those lawyers is going to be handling your two cases. Get that lawyer here, get you here, and we can move things forward. You got any questions?
Okay, yes, and you said somebody with 2 aggravated assault cases.
Correct. One is from September 24 and one is from October 25.
They failed to prosecute me on that case in 2024. I don't know why it's showing up like that.
So what may have happened in that case when you say failed to prosecute is that you had a preliminary hearing and I'm going to look the case up. The officer didn't show up and a judge dismissed the charges, but the judge dismissed unindicted charges. And the district attorney's office has the authority to go ahead and indict even though something like that happened. So let me take a look here. No, you through a lawyer waived your preliminary hearing in October of 24. You got a bond and then nothing happened for half a year, 6 months. But then you got indicted in April of last year for that situation. Something got reduced to a misdemeanor, et cetera, et cetera. But either way, you've been indicted for both. We need to get your lawyers to coordinate so one can represent you, and then we'll move everything together. We'll talk about bond. We'll talk about next steps, okay?
Okay. Yes, sir.
Any other questions?
No, sir.
All right, I'll see you soon.
They'll see you on screen.
Whoa, who's in Cobb? Mr. Sanders. All right.
Majority, I have 3 out here actually that are scheduled for the bond hearing.
Oh, great. Can you give me the name, sir?
Yes, the first one is this gentleman here now, Darius Sanders.
Got the name. Yep.
The next one is George Rivera.
Jorge Rivera. Got it.
The next one looks like Jamiron Brown.
Got that one too. Excellent. Thank you, sir.
All right, you're welcome.
All right. Ms. Rios, are you handling the revocation with position 11?
Yes, Your Honor.
Is that something you and Ms. Smith have already discussed?
Ms. Simpson, we've emailed about this case. Well, I just emailed Ms. Simpson about and what her recommendation's going to be. I think we should put this down for a hearing.
Got it. As in an evidentiary hearing.
Yes, Your Honor.
Okay.
Yeah.
All right. Let me find his Sanders. Okay, got it. So Mr. Sanders, let me get you on the screen here so we can see you better. And Ms. Rios. All right, Mr. Sanders, you got picked up. I don't know if the probation warrant is what got you picked up, but you are being held in part because of a probation warrant I signed and a petition that you'll be signing soon. That alleges you violated a bunch of conditions of your probation. And it sounds like there's a pretty big gap between what the state is recommending and what your lawyer is recommending. You are entitled to a hearing where the state has to prove up one or more of the alleged violations before I could revoke any of your probation at all. And Ms. Rios is saying that that's what we need to do, is give you that hearing to shift the burden over to the state so they can prove up whatever it is they're going to try to prove up. And then I can figure out what the outcome should be. Does that make sense?
Yes, sir.
Any questions?
Yes, what the state asking for?
Ms. Rios, have you and Mr. Sanders had a chance to talk about this, or I don't want to get in the way of your discussions?
No, Mr. Sanders, when we talked, I didn't have an offer yet. They want to revoke 5 years, I believe.
5 years?
Yes.
Is it a reason why they want to revoke 5 years? You told
We can
me?
come, I will talk to you about that a little later. We'll set the time for us to talk, for us to go into that, but that is their recommendation.
So, Mr. Sanders, you're asking a great question, and Ms. Rios will give you her perspective as to why the state or probation or both think that that's the right amount to revoke. I, of course, need to hear from both sides, and I'll do that, but that's only after the state proves up one or more of the violations that are in the warrant and the petition. So I'll get you back here soon. It'll be in person, not over Zoom. And we'll have that evidentiary hearing if between now and then your lawyer and the prosecution don't sort something out. Okay?
Yes, sir.
All right. Appreciate you being here.
Thank
Ms. Smith, anything from the state on Mr. Sanders' case? Okay. All right. Can we knock out, well, if he doesn't have Jorge Rivera quite yet. Ms. Wood, you're handling that. It's not a revocation, so.
It's a plea, Judge.
Okay. Let's. Trying to track a few of these other people down.
Mr. Williams is in 5 North Booth 1, Judge. Position number 6.
Oh, we already spoke. He was in booth 4. Did he move? He was where it said on your list. You have listed a Mr. Reeves, but I don't have him on the calendar.
Please the add-on jail calendar. I'll bring it out to you.
Okay, thank you. Oh, and I didn't realize we have a number 16, which is why Mr. Melnick may be here.
I believe I was an add-on.
Are you Terrell Bond?
Yes.
Okay, no, it's on the regular one. I didn't flip over the last page. And he is in 2 South Booth 1. Okay, let's see if we can get him up on the screen. Hey, Mr. Bond, can you hear me? Thank you. Can you say that again?
Yes.
Great. You're going to need to speak up a little bit. You're hard to hear. Let me get your lawyer on the screen as well. Let's see if we can get him. There he is. You can see most of him. That's Mr. Melnick. Ms. Willingham, are you handling this?
Yes, Your Honor.
Okay, let me get you on the screen. Okay. So Mr. Bond, you are on the calendar to set aside a bench warrant. Mr. Melnick, why don't you tell me why that should happen.
Okay, Your Honor. Good afternoon. So I'm just going to give you sort of a brief procedural history so you understand kind of how we are, where we are here. Mr. Bond was arrested for these charges on July the 7th of 2024 and released on August the 29th of 2024. A condition of his release was to wear an ankle monitor. And he obviously had the ankle monitor. So the procedures.
Was he paying for it, or was it county funded?
At that time, I believe that county funding had ceased. He was paying for it.
Oh, okay.
Yeah. So Your Honor, I've been in touch, I can say as an officer of the court, I've been in touch with Second Chance Ankle Monitoring. They are willing to come back on his ankle monitor. There was never a motion to revoke his bond or to inquire as to his status with the ankle monitor. But he was on an ankle monitor compliance hearing in front of Judge Manning on December the 1st of 2025. He did not get a notice for that, and therefore did not appear. And then he came in to the Clerk of Superior Court, ironically, on December the 2nd of 2025 and filed a change of address. So actually walked into the courthouse and said, "Hey, I've moved, so here's my new address."
Okay.
So judicial hold was issued as a result of the failure to appear on December the 1st. Your Honor, at the time, Mr. Bond was represented by
Mr. Mubin.
Mubin, right. I have reached out to Mr. Mubin, and I have not been able to get in contact with him to see what notice he may have had. But I'm assuming he would have gotten a notice for it, but he never told Mr. Bond. Mr. Bond does have some prior criminal history, Your Honor, but it's mostly old stuff. It's mostly very minor stuff. And so he doesn't have a lot of experience. And quite honestly, this type of procedure of having to come in for a random ankle monitor compliance hearing is something that most people don't really have to deal with. And it obviously took place a year and a half after he was on the ankle monitor with no apparent issues with regard to the continuing, monitoring that was taking place.
So it may well have been an opportunity
Have it removed.
correct,
Yeah.
that it would have been a happy result rather than a bad result.
That's probably correct. In any event, Your Honor, he certainly had no reason, any willful reason to fail to appear for that. I'm not even 100% sure that he had an arraignment. No, I guess he did have an arraignment on October the 28th. And there were certainly no issues with that. His attorney filed a waiver of arraignment. His attorney then filed a motion to withdraw on November the 18th of 2025. And I don't know, again, Mr. Mubin has not contacted me about this situation. So Your Honor, Mr. Bond has his own trucking company called TMB Carriers LLC. He owns a couple of box trucks, and he's been doing that for a very long time. He's 46 years old. He has 3 children, ages 28, 10, and 8. Well, as I indicated, Judge, he does have some prior history. In looking through his history, and I don't have it right up here in front of me, I didn't see anything that was any sort of domestic violence related type of history. Your Honor, I believe that this was a misunderstanding. Mr. Bond has now been in jail based on this judicial hold since February the 1st of this year. Actually, longer than that, because he was driving his truck when he got arrested for this and was in Mississippi and had to be extradited from Mississippi. So that added about 2 weeks. His brother is present in court here, Your Honor, and it's my understanding that their mother has taken a significant turn for the worse with cancer and is basically on her deathbed, as I understand it.
Sorry to hear that.
So, Your Honor, I don't believe that there was any willful failure to appear, and that this was done with the intent of impeding the judicial process, given the nature of what it was that he failed to appear for. And I'm asking that you simply reinstate the bond as previously ordered.
Okay. You are officially in, it looks like,
Filed entry and everything, yes.
Yep, you did. There it is. Okay. Yeah, you show up in the system. I just saw Mubin leaving and didn't see you coming in, but you're in. Mr. Bond, couple questions for you, then I want to hear from the prosecutor. So what is your current address? What street name and city do you live in?
5087 Lake Bridge Lane, Stone Mountain, Georgia. I think that's 30087.
All right, I have 5085 Lake Brook Run.
Lake Brook Run. It's 5087.
Okay, well, we may get Mr. Melnick to modify that. Next question. When did you move there?
In December.
Okay. Did you used to be on Shafford Court in South Fulton?
Yes, sir.
Okay, because the notice was sent to you at Shafford Court, South Fulton, back in November to be there for the December calendar.
I didn't receive it, Your Honor, but I have no intentions of not showing up for court. Like I said, like the lawyer had said, it was no intentions for me not to show up for court. If I'd have got the hearing or the paperwork, I would have been there.
Okay. Where's your box truck?
In the pound in Mississippi. They arrested me. They arrested me January 14th. I was dropping the load off in Tippecanoe, Tupelo, Mississippi. They arrested me in DOT, just a DOT pullover. They arrested me. I passed the inspection check, but when they ran my name, they said I had an outstanding warrant for Fulton and for this case right here. And I was like, no, I shouldn't have a warrant, because I was up. I came to the courthouse and I checked for everything, gave a change of address. I asked for a court date. I was actually told a court date was supposed to be February 13th. But I don't know, whatever happened. So they arrested me. And when I got downstairs and went through intake here, they said I had court March 3rd. So I don't know, Judge. I don't know. But I have no intentions on not showing up for court and putting this case behind me, though.
Okay. Ms. Willingham, what are your thoughts about reinstating the bond? I see a bond pre-indictment for $55,000 with an ankle monitor paid for by Fulton County. No contact with a Whitney Blanks.
Your Honor, in preparation for today, the no contact part of that bond order would actually be my concern. As I spoke with Ms. Blanks, I've talked to her a couple times, but when I spoke with her on the 18th, she mentioned that she wasn't certain exactly of the date, but that the defendant's brother actually reached out to her to have her sign a affidavit. And she's also mentioned that the defendant reached out to her. Now she does acknowledge that she responded back to the defendant, but that would be a bit of a concern. And I know there was never a motion to revoke bond filed because I was notified of it in speaking with Ms. Blanks in preparation for this hearing. So that would be my biggest concern, would just be the no contact aspect of that bond. I recognize that based on why he was revoked at this point, or why he's back in custody, I recognize that that doesn't necessarily have anything to do with what I've just said, doesn't necessarily have anything to do with why he's back in custody, but it would bring a concern for me.
Sure. No, that makes sense. The contact that Ms. Blanks was describing was a text or a telephone, or was the defendant or his brother actually like in her doorway saying, I'm here, you need to sign this thing?
So in speaking with her, she said that the brother texted her and the defendant emailed her.
Okay. So it was contact, but it was at least virtual as opposed to showing up at her work or at her home.
Correct.
Okay, all right. Anything else on the state's part?
No, Your Honor.
Okay. Mr. Melnick, anything more on behalf of Mr. Bond?
No, Judge, I don't know anything about this contact. I spoke with Ms. Blanks, and she had indicated to me that she had not had any contact with the defendant. She wanted to keep it that way.
Good.
That there was she did not have any opposition to him being out on bond.
Okay. Well, Mr. Bond, I'm going to reinstate your bond with the reminder that you may not contact Ms. Blanks in any way, shape, or form. No email, no Instagram, no Telegram, nor can you use a family member or a friend to do that. It would be just the same as you doing it if your brother or your aunt or someone else reached out to Ms. Blank saying, hey, sign this affidavit that it didn't happen the way it says in the police report, or I don't want to prosecute or anything like that. If you, your lawyer can have outreach to Ms. Blanks. You may not, and no friends or family member. That's the quickest way to have your bond go away in the future. Because of this concern that Ms. Willingham has raised, I'm going to have that ankle monitor go back on. It will be a county-funded ankle monitor. If for some reason this case moves real slowly, you should know that for now, we just do 6 months. The new standard for ankle monitors is they go on for 6 months and they come off automatically unless I agree to extend it. But I have to take some affirmative action to extend it. And I probably won't extend it. I'll probably revoke your bond if Ms. Willingham presents verifiable evidence that you or a sibling or a friend tried to reach out to Ms. Blanks. Okay?
Yes, Your Honor.
Any questions about that?
No, sir.
Okay, Mr. Melnick, I need you to fill out a change of address form. I think we're off by 1 digit, but what's in the system is 5085, and it was a slightly different sounding street name. So if you could just make sure it's, do you know your brother's address, or do we need him to repeat it again? Okay. Mr. Bond, say it slowly. What is your home address?
5087 Lake Brook Run, Stone Mountain, Georgia. 30087.
All right. Say the 4 digits one at a time.
5087.
Okay. Got it.
And is it Lake Brook Road or Lake Brook Run?
Lake Brook Run.
Run. Okay, Lake Brook is one word, correct?
Okay, so we're just off by 1 digit. It was going to 5085, but you didn't miss any court with this new address. You missed it with the old address. I'll take care of that paperwork. You probably are not going to get out till Monday. I don't want you thinking, hey, I'm getting out in 5 minutes. We'll try to process the paperwork, but there's a lot flowing this afternoon, okay?
Okay, yes.
Ms. Willingham, anything else on behalf of the state?
Nothing further, Your Honor.
All right, thank you.
Thank you, Judge.
You're welcome. Bond. All right, Mr. Bond, you are free to go.
Thank you.
Judge, present this to you, Judge.
Sure. All right, let's knock out our matters that have our interpreter here because he is stuck.
Judge, I'm sorry. I just realized you mentioned that Ms. Cabrera will not be present. So with that, that concludes my business. May I be excused?
Yes, ma'am. What was your other case?
I had one of Mr. Huey's cases, and then I had Mr. Johnson, and Ms. Woods announced on that. That's the one that's the speedy.
Okay. Yeah, you don't need to. I'm going to get Mr. Johnson on the screen and talk with him, but I don't know that you need to stick around for that. That's up to you.
I trust that the people in the courtroom, if there's anything substantial, they'll let me know.
Or I know Miss Smith will at least, so you'll be good to go.
Okay,
All right.
thank you, Judge.
You bet. Are you Senor Rivera? All right, we need to get Cobb to unmute the booth. Can you ask him to get the officer to come unmute, please?
Señor Rivera, por favor pida al oficial que prenda su micrófono ahí en la butaca.
Yes,
Thank you,
sir.
sir.
Uh-huh.
All right. Good afternoon, Mr. Rivera.
Señor Rivera, buenas tardes.
Buenas tardes.
Good afternoon.
Ms. Wood, tell me what we're doing with Mr. Rivera.
Señora Wood, por favor, dígame qué es lo que estamos haciendo aquí con el señor Rivera.
We are doing a misdemeanor plea on this case, Judge.
Okay.
Él tomará una declaración ante un delito menor.
Then let me swear an interpreter first.
Entonces, primeramente, juramentaré el intérprete.
Sir, do you swear or affirm that you will translate to the best of your ability from English to Spanish and Spanish to English?
Yes.
And would you state your name for the court reporter, please?
Juan Bernal,
Can you spell your last name?
Bernal.
We will do our best to break this down into bite-sized chunks.
Thank you. The interpreter will appreciate that.
This is case 25 SC 003612.
Este es el caso enumerado 25 SC 003612.
Mr. Rivera is represented by Ms. Wood.
El señor Rivera está siendo representado por la señora Wood.
And Ms. Smith, if you can stay where you are. You just need to move the camera so that Ms. Rivers can see you.
Y abogado, usted puede quedarse sentado ahí. Le pido que por favor mueva la cámara a modo que usted salga en pantalla.
The state is represented by Ms. Smith.
La Fiscalía Estatal está siendo representada por la señora Smith.
Mr. Rivera, in a moment, Ms. Smith is going to put you under oath.
Señor Rivera, en un momento la señora Smith le juramentará a usted.
Okay.
If you have questions at any time, please let the translator know.
Si en algún momento usted tiene alguna pregunta, por favor hágasela saber al traductor.
Okay.
Ok.
Ms. Smith?
Señora Smith.
Mr. Rivera, please raise your right hand.
Señor Rivera, por favor levante su mano derecha.
Do you swear or affirm that the testimony you shall give in this matter
¿Usted jura o afirma de que el testimonio que usted dará ante este asunto
currently before this court shall be the truth, the whole truth, and nothing but the truth?
que ahorita está presente ante esta corte será la verdad, completamente la verdad y sin omisiones?
Lo juro.
I swear.
Okay, you can lower your hand.
Muy bien, puede bajar la mano.
Please state your true, correct, and legal name for the court.
Por favor, diga ante la corte su nombre correcto, legal y verídico.
Jorge Morales Rivera.
Jorge Moray Rivera.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Ahorita usted está tomando o está bajo la influencia de alguna droga, medicina o alcohol?
No.
No.
Is there any medication that you would normally take that you haven't been given today?
¿Hay algún medicamento que usted generalmente toma, el cual usted no ha tomado el día de hoy?
No.
No.
How old are you and how far have you gone in school?
¿Qué edad tiene usted y hasta qué año llegó en la escuela?
Tengo 40 años y terminé mi cuarto año. Tengo 40 años y terminé high school.
I am 40 years old and I finished high school.
Are you able to read, write, and understand the English language?
¿Usted puede leer, escribir y entender el idioma inglés?
Puedo entender solamente un poco. No lo puedo leer, no.
I can understand it a little bit, but I cannot read it.
Are you able to understand what we are saying with the assistance of Mr. Bernal?
¿Usted puede entender lo que estamos diciendo por medio de la ayuda del señor Bernal?
Sí. Con
Yes.
con ayuda, sí.
Yes. With the help? Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
¿Entiende usted de que usted tiene el derecho de declararse ya sea culpable o que no es culpable ante estas acusaciones?
And if you plead not guilty or remain silent, you may receive a jury trial.
Y si es que usted se declara que no es culpable o si guarda silencio, de que usted podrá tener un juicio ante un jurado.
Sí.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
¿Ha tenido usted suficiente tiempo para hablar con su abogado con respecto a los hechos y las circunstancias con respecto a las acusaciones que han sido levantadas en contra de usted?
Sí.
Yes.
Do you need more time to discuss your case with your attorney?
¿Necesita usted más tiempo para hablar con su abogado?
No.
No.
And are you satisfied with her services?
¿Y usted está satisfecho con los servicios de ella?
Sí.
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Se le pregunta a la abogada si es que ella está satisfecha de que su cliente tiene un entendimiento de este proceso.
Yes.
Sí.
Do you also waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Y se le pregunta a la abogada si es que ella está dispuesta a descartar la lectura oficial de la acusación oficial, lo cual también incluye el descartar cualquier imperfección que haya dentro de dicha acusación y documento.
We do.
Y está de acuerdo con ello.
Mr. Rivera, do you remember being arrested on these charges?
Señor Rivera, ¿se acuerda usted que se le arrestó o cuando se le arrestó con respecto a estas acusaciones?
Sí.
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
Y señor Rivera, la fiscalía tiene por entendido de que no hay ninguna otra orden de arresto en contra de usted con respecto a estas acusaciones. ¿Acaso, señor Rivera, hay alguna otra orden de arresto en contra de usted con lo que respecta a estas acusaciones?
No.
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 36 months of probation?
Señor Rivera, ¿entiende usted de que esta es una declaración de culpabilidad que ha sido negociada, la cual lleva como parte de esa negociación un plazo de probación de 36 meses?
Sí.
Yes.
Are you aware that the court does not have to accept that recommendation and can sentence you to the maximum on each charge?
¿Y entiende usted de que la Corte no tiene que aceptar esta negociación y de hecho de que la Corte podría condenarle a usted a la condena máxima?
Sí.
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
¿Y entiende usted de que si es que se le pone a usted bajo probación, de que usted no puede quebrantar ninguna ley de ninguna entidad gubernamental?
Or any special conditions of probation without being subject to revocation for the balance of the sentence?
Y tampoco puede quebrantar ninguna parte de su acuerdo de probación, incluyendo a condiciones especiales de probación, porque en dado caso, esto podría causar de que se le revoque el resto de su plazo de condena.
Sí.
Yes.
Understand that this is a guilty plea, which is permanently recorded on your criminal history.
Señor, ¿entiende usted de que esta es una declaración de culpabilidad, la cual quedará grabada permanentemente en su expediente penal?
Sí.
Yes.
Do you understand that if you're charged with a crime in the future, this plea may be used to enhance that sentencing, even on a federal case?
¿Entiende usted de que al declararse culpable, que esto quedará en su expediente penal y de que se podría utilizar para aumentar alguna condena que usted pueda recibir en algún tiempo futuro, incluyendo ante un caso federal?
Sí,
Yes.
Are you currently on probation?
¿Está usted ahorita bajo probación?
no,
No.
Are you a United States citizen?
¿Es usted un ciudadano de los Estados Unidos?
sí,
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
¿Entiende usted de que al declararse culpable, de que usted descarta cualquier defensa que usted podría montar, incluyendo alguna defensa con lo que respecta a salud mental?
sí,
Yes.
Do you understand that by pleading guilty, you are giving up the following rights? The right to a trial by jury,
¿Entiende usted de que al declararse culpable, de que usted está renunciando a los siguientes derechos? El derecho de tener un juicio ante un jurado,
the right to remain silent and not incriminate yourself,
el derecho de guardar silencio y de no incriminarse a sí mismo,
the right to see and hear the witnesses called to testify against you,
el derecho de ver y de escuchar a los testigos citados en contra de usted testificar,
the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney,
el derecho de tener la asesoría de un abogado, ya sea un abogado que usted mismo contrate o si usted no tiene los fondos, a que se le asigne un abogado defensor para que le represente a usted.
the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges.
El derecho de que se le tome a usted como inocente, lo cual quiere decir de que la fiscalía tendría que comprobar las acusaciones en contra de usted más allá de una duda razonable.
The right to testify on your own behalf or remain silent,
El derecho de testificar a favor de sí mismo o de guardar silencio.
the right to present other evidence of your own and call your own witnesses,
El derecho de brindar sus propias evidencias y también de citar a sus propios testigos.
and the right to appeal if convicted of these charges after a trial.
Y el derecho de apelar después de un juicio si es que se le llega a condenar a usted.
Do you understand that these are the rights you're giving up by entering this guilty plea today?
¿Entiende usted de que al declararse culpable el día de hoy, de que usted está renunciando a estos derechos?
sí,
Yes.
Counsel, are you satisfied your client understands these rights that they'll be waiving by entering this guilty plea?
Se le pregunta a la abogada si es que ella está de acuerdo de que su cliente entiende de que él renuncia a estos derechos al declararse culpable
I am.
y está satisfecha con eso.
Mr. Rivera, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
Señor Rivera, ¿acaso alguien le ha prometido, le ha amenazado o le está forzando a usted para que usted se declare culpable?
no,
No.
As to indictment number 25SC 003612, how do you plead to count one, terroristic threats and acts?
Y señor Rivera, con respecto a la acusación enumerada 25 SC 003612, la acusación número 1 de acciones y amenazas terrorísticas, ¿cómo desea declararse?
culpable.
Guilty.
Your Honor, for this count is indicted as a felony, but I forgot to mention that it's being reduced to a misdemeanor.
For the
Señoría,
terroristic threats?
Yes.
con respecto a este caso, permítame decirle de que fue acusado como un caso de un delito mayor, pero ha sido condenado como un delito menor. El juez preguntó si es lo que respecta a las amenazas terrorísticas. La abogada Smith indicó que sí.
And the public drunkenness is a misdemeanor. The obstruction is already a misdemeanor?
Yes.
Y el estar ebrio en público es un delito menor. Ahora también la obstrucción de un oficial del cuerpo policíaco también se trata como un delito menor, indica la abogada Smith que sí.
Mr. Rivera, how do you plead to count 2, willful obstruction of law enforcement officers?
Señor Rivera, ¿cómo es que se declara usted ante la acusación número 2, la obstrucción adrede de un oficial del cuerpo policíaco?
Culpable.
Guilty.
How do you plead to count 3, public drunk?
¿Y cómo es que se declara usted ante la acusación número 3, el estar borracho en público?
Culpable.
Guilty.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Y usted se está declarando culpable, libre y voluntariamente con un conocimiento de la acusación en contra de usted?
Sí.
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea?
¿Entiende usted de que usted no tiene el derecho de apelar directamente su declaración de culpabilidad?
But if you believe there is some error in your guilty plea,
Pero si usted cree que hubo algún error en su declaración de culpabilidad,
you can apply to the appropriate appellate court to request a discretionary appeal.
de que usted podría apelar de que usted podría tramitar una apelación al Tribunal de Apelaciones.
And do you understand that that has to happen within 30 days from today?
¿Y entiende usted de que esto tendría que suceder dentro de 30 días a partir de la fecha del día de hoy?
Sí.
Yes.
Do you understand that you have only 12 months from today for a misdemeanor charge?
¿Entiende usted de que usted tiene un plazo de 12 meses con lo que respecta a una acusación de delito menor
To file a habeas corpus petition challenging the voluntariness of this guilty plea?
para tramitar una apelación llamada habeas corpus con lo que respecta a si es que usted se declaró voluntariamente en esta forma el día de hoy?
Sí, entiendo.
Yes, I understand.
Thank you, Mr. Rivera.
Gracias, señor Rivera.
Your Honor, if this case were to proceed to trial, the state would show
Su señoría, si es que este caso marchase adelante y se tuviese que pelear ante un juicio, la fiscalía mostraría
that on February 2nd, 2024, officers responded to an intoxicated individual call
de que el 2 de febrero del 2024 los oficiales del cuerpo policiaco atendieron a una llamada
located at 9955 Dogwood Road in Roswell, Georgia.
de que ellos acudieron al 9955 Dogwood Road en Roswell, Georgia.
When officers responded to the scene, they spoke with victim Beverly Lowe,
Cuando los oficiales acudieron al lugar de los hechos, ellos charlaron con la víctima Beverly Lowe,
who informed the officers that the defendant threatened to kill her.
la cual le informó a los oficiales de que el acusado amenazó matarla.
This threat was witnessed by a Kenneth Story.
Y esta amenaza fue vista y presenciada por una persona llamada Kenneth Story.
After making contact with the defendant began to walk away from the officers.
Después de hacer contacto con el acusado empezó a caminar alejándose de los oficiales.
The defendant had a distinct odor of alcohol beverage on his body, bloodshot eyes, and watery eyes also.
El acusado tenía un olor fuerte a alcohol. También se le mostraba que los ojos los tenía rojos.
At this time, the defendant was taken into custody and charged for the charges we have in front of us today.
Y en ese entonces se le detuvo al acusado y fue tomado bajo custodia y se le acusó de las acusaciones que tenemos ante nosotros.
And all of this occurred in Fulton County.
Y todo esto sucedió en el condado de Fulton.
And those are the facts of the case, Your Honor.
Y su señoría, esos son los hechos del caso.
Regarding the negotiated plea between the state and the defense,
Con respecto a la negociación que se llevó a cabo entre la Fiscalía Estatal y la defensa,
we've agreed to a sentence of 36 months for 12 months probation for each count to run consecutive.
nosotros hemos llegado a un acuerdo de una condena de 36 meses. Son 12 meses por cada una de estas ofensas y las condenas se llevarían a cabo consecutivamente, dándonos un total de 36 meses.
Regarding the special conditions of probation,
Con respecto a las condiciones especiales de aprobación,
the state is recommending a drug and alcohol evaluation with treatment if necessary,
la Fiscalía está recomendando una evaluación con respecto a las drogas y el alcohol y tratamiento, si es que es necesario,
for the defendant to stay away from the incident location,
de que el acusado se mantendrá alejado del lugar del incidente
for the defendant to have no contact with the victim in this case,
y de que el acusado no tendrá contacto con la víctima, en este caso,
for the defendant to complete an anger management course,
para que el acusado lleve un curso con respecto a el manejo del enojo
and lastly, that the defendant be banned from Fulton County.
y, por último, de que el acusado se permanecerá alejado del condado de Fulton.
The state did get an opportunity to speak with the victim in this case.
La Fiscalía Estatal tuvo la oportunidad de hablar con la víctima. En este caso,
This is Ms. Lowe.
Yes.
¿es la señora Lowe? Sí.
She informed us that she has forgiven the defendant,
Ella nos informó de que ella ha perdonado al acusado,
that she believes in second chances,
de que ella cree que hay segundas oportunidades
and that she just wishes for no contact with the defendant.
y de que ella desea no tener contacto con el acusado.
And what is their connection? Strangers?
Strangers. She
¿Y
is
cuál es su conexión? Son desconocidos.
the manager of the building that the defendant was at the time of his arrest.
Okay.
Ella es la manager del edificio ante el cual el acusado estaba presente en ese entonces.
And that is all from the state, Your Honor.
Y señores, esto por parte de la Fiscalía Estatal.
Thank you. I believe we have someone, yes, Officer Stallworth from pretrial.
Ya, sí, me parece que tenemos al oficial Starward del Departamento de Servicios Previos a un Juicio.
Yes, he has 20 cycles,
Así es, él tiene 20 ciclos,
10 out of the state of Florida, 1 out of the state of Louisiana, 1 out of Mississippi, and 3 out of Texas, 2 out of Puerto Rico. I'm sorry, you need me to start?
An interpreter requests that the previous statement please be repeated and broken down into smaller chunks.
Yes, sorry. The first 10 cycles were Florida,
El intérprete ha pedido que se repita la oración previa. Ha indicado de que tiene 10 ciclos del estado de Florida,
1 out of Louisiana,
1 de Luisiana,
1 out of Mississippi,
1 de Mississippi,
3 out of Texas,
3 de Texas,
2 out of Puerto Rico.
2 de Puerto Rico.
There's a 2018 conviction
Hubo una condena en el 2018
out of Orange County, Florida,
del condado de Orange en la Florida
for possession of cocaine.
por posesión de cocaína.
There's an active warrant
Tiene una orden de arresto que está activa
out of Fulton for FTA.
del condado de Fulton por no comparecer a una audiencia.
Date of that warrant
La fecha de esa orden de arresto
is April the 25th of 2025.
es el 25 de abril de 2025.
There is a conviction outside of the 10-year period.
That's okay. I'm good with what you shared. Thank you.
Okay, you're welcome.
Hay una condena más allá de los plazos de 10 años y el juez indica que está bien. ¿No se necesita eso? Gracias.
Ms. Wood.
Señor Wood.
Thank you, Judge. Mr. Rivera has no ties anymore to Georgia or Fulton County.
Gracias, juez. El señor Rivera ya no tiene ningún lazo con lo que respecta a Georgia o al condado de Fulton.
He lives in southern Mississippi with his wife, Melissa, who is actually on this call.
Él, de hecho, vive en la parte sur de Mississippi con su esposa, quien, de hecho, está en esta llamada.
And so as part of our negotiations, we just wanted to make sure that everyone understood that he has no reason to be back in Georgia after he's resolved this case.
Y pues eso es parte de nuestra negociación. Y nosotros queríamos hacerles saber de que una vez que este caso quede resuelto, él ya no tiene nada que lo ligue al estado de Georgia.
Ms. Wood, is it your experience with misdemeanor probation
Y señor Wood, ¿es su experiencia con lo que respecta a aprobación, con lo que respecta a delitos menores,
that they will supervise people virtually out of state?
de que ellos supervisarán a gente fuera del estado?
Yes, Judge. However, I'm glad you brought that up because
Sí, juez, y gracias. Me alegra de que usted lo ha mencionado.
right before the call, I remembered that there could be an issue with JCS, which is the misdemeanor probation folks.
De que, pues sí, de hecho, me acordé justo antes de esta llamada de que quizás surja alguna cuestión con lo que respecta al departamento de probaciones, con lo que respecta a delitos menores,
With supervising a Spanish-speaking client.
con el supervisar a un cliente de habla hispana.
I did share that information with Ms. Smith,
Y compartí esa información con la señora Smith.
and I reached out to them, but I haven't received an email back yet.
Y yo me he puesto en contacto con ellos, pero ellos no me han regresado el correo electrónico.
So with that being said, I am asking the court to perhaps suspend the sentence.
Y habiéndose dicho eso, pues me gustaría pedir a la corte que quizás suspenda la condena.
He has served actually 196 days for this case.
Y de hecho, él ya ha servido 196 días con lo que respecta a este caso.
It's 3 separate booking numbers, and I sent those to Ms. Nelson. I can put those on the record if needed.
I have the same math you do. I've already found those dates.
Y pues de hecho son 3 diferentes números de orden de arresto. El juez indica de que sí, él tiene las mismas fechas y las mismas cifras y ya ha cuadrado las cifras.
So that's our request, Judge. I appreciate Ms. Smith working with us on this one. Mr. Rivera is eager to get out of Georgia and back to Mississippi.
Y su señoría, ese es nuestro pedimento, es el acuerdo que nosotros hemos llegado a tener con la señora Smith, y el señor Rivera está ansioso por salirse de Georgia e irse a Mississippi.
Mr. Rivera, do you have any questions?
Señor Rivera, ¿tiene usted alguna pregunta?
No, sir.
No, sir.
I find there's a factual basis for your plea.
Yo veo de que hay hechos ante los cuales usted se ha declarado
And that your plea is knowing and voluntary.
y de que usted se ha declarado con conocimiento y voluntariamente.
Which means you've understood what we've said.
Lo cual quiere decir de que usted ha entendido lo que hemos dicho.
And no one is forcing you to enter this plea.
Y de que nadie le está forzando a que se declare de esta forma.
Do you agree with that?
¿Usted está de acuerdo con esto?
Sí, señor.
Yes, sir.
Ms. Wood, can someone in my office sign the indictment for you?
Señor Wood, ¿acaso hay alguien en mi oficina que podría firmarle por usted?
Yes, Judge.
Ms. Smith, same question?
Yes, Judge.
Se le hace la misma pregunta a la abogada Smith, indica que sí.
And Mr. Rivera, can someone in my office sign the indictment for you?
Y señor Rivera, ¿acaso alguien en mi oficina podría firmar su nombre?
Sí.
Yes.
Mr. Rivera, I'm going to sentence you on count 1 to 6 months in custody.
Señor Rivera, yo le condenaré a usted con respecto a la acusación número 1 a servir 6 meses de encarcelamiento.
Count 2 will be 1 year, or be 12 months.
Y con respecto a la acusación sería 1 año, no, disculpe, 12 meses.
Count 3 will be 12 months.
La acusación número 3 también será 12 meses.
Those will run consecutive to each other.
Y esos se llevarán a cabo consecutivamente uno con el otro.
And to count one.
Y con la acusación número 1.
So it's a total sentence of 30 months.
Y es una condena total de 30 meses.
6 months in custody.
6 meses de encarcelamiento.
And 24 months.
Y 24 meses
suspended.
Suspendidos.
There are 2 conditions of your suspended sentence.
Hay 2 condiciones de su condena suspendida.
Number 1 is no contact with Ms. Lowe.
Número 1 es que no tendrá contacto con la señora Lowe.
Number 2 is that you are banished from the state of Georgia.
Y número 2 es de que usted permanecerá eliminado del condado de Georgia.
With the exception of the Waycross Judicial Circuit.
Con excepción del circuito judicial de Waycross.
So basically you need to stay out of Georgia, but if you really need to come to Georgia, you can only go to that circuit.
Y pues básicamente usted tendrá que mantenerse alejado del estado de Georgia. Pero en dado caso de que usted realmente tenga que venir a Georgia, solamente podrá ir a ese circuito.
Do you understand that?
¿Entiende usted eso?
Sí, señor.
Ms. Wood, Ms. Wood, anything else on behalf of Mr. Rivera?
Señora Aguda, ¿algo más a favor del señor Rivera?
No, Your Honor, thank you.
Ms. Smith, anything else on behalf of the state?
No, Judge.
Indicó la abogada Wood que no, señoría. Se le hizo la misma pregunta a la abogada Smith, también indicó que no.
Mr. Rivera, you should be released early next week. I will sign the paperwork today, but it may take over the weekend for it to be processed.
Y señor Rivera, yo firmaré el papeleo el día de hoy, pero pues puede que se tarde todo el fin de semana, a modo de que probablemente le darán a usted en libertad a principios de la próxima semana.
When you are released, you need to leave Georgia. Do you understand that?
Cuando se le ponga a usted en libertad, usted tiene que salirse del estado de Georgia. ¿Entiende eso?
Sí.
Yes.
How are you getting home?
¿Cómo es que regresará a casa?
Greenhouse bus o mi novia me viene a buscar.
Either a Greyhound bus or my girlfriend's going to come get me.
Sounds like a plan.
Parece que ya tiene un plan.
Good luck.
Buena suerte.
Gracias.
Thank you.
We need to do Mr. Reeves next. He is in medical, and I've been asked to do that next. I don't know what, oh, there's something called medical. There it is. I've been asking around, where the heck is medical? And it's right there. Excellent. Let me, oh, and someone just unmuted it. Fantastic. Let's get Mr. Reeves. Ms. Rios, that is you.
Yes, Your Honor.
Let's add you. Okay. What are we doing today with Mr. Reeves? He missed court. This is a older case, and he's now in custody, picked up on a bench warrant.
Your Honor, I did file a motion to set aside the bench warrant. My investigator went to go talk to him to find out what happened. I didn't file a waiver because I wasn't sure if he wanted me to stay on his case, because he let her know that he would possibly be hiring a private attorney. So I'm not sure if that's still the case.
Okay. Well, let me start by then asking you, Mr. Reeves, tell me what your plan is. Are you planning on hiring a lawyer?
Yes, sir. I'm planning on hiring a lawyer after, depending on how my surgery go. I have surgery with my broken neck and my leg, so I don't know how long that's gonna take me, but I know it's gonna be 6 months to a year of bed rest before after I do surgery to heal, and then I got physical therapy to teach me how to walk again. So I plan on hiring an attorney and fight the case.
Where, just so I can understand, oh, there's someone in court for you. Who is here?
That's my fiance.
Fiance is here. Okay. She may be able to help me understand. It sounds like you're going to be out of commission for a while, which probably means you're not working, which makes me think, how are you going to hire an attorney? Please, hold on, Mr. Reeves.
I'm sorry.
So, he had a injury at work, so he has like work stuff going on right now.
Okay.
The reason he missed the court date is because we ended up moving and we never got the new court date.
Okay.
We did not notify anyone, but we, never received the court date, that's why he didn't go. So I usually make sure he's on top of his things and make sure he gets to court and stuff and his doctor's appointments, but.
So I have two different addresses in the system. One is from Fairburn and one's from Douglasville.
So we currently live in Douglasville. We moved to Douglasville when I was pregnant, November 2023.
Okay. Sutton Place.
That's where we live now, that's where we've been.
Got it. But he at least used to be at Smoke Ridge Drive in Fairburn.
Yes, that's where we used to live together.
Okay. And you moved together to the Douglasville address.
Yes.
Are you working?
Yes.
What do you do?
I work for Toyota.
Okay. So you have an income and Mr. Reeves has workers' comp. So there's money coming in. And Mr. Reeves, it is your desire to hire an attorney?
If I haven't talked to her, it seems like she's pretty good. If me and her can just talk to each other personal, and she can speak to me, like I really don't know how the case is going because it's so long, but I don't mind hiring her if I can.
Well, unfortunately, she's not for sale. But it also would be a question of whether you financially qualify. If you're getting workers' comp, my guess is you do qualify, but I don't mean to speak for Ms. Rios and her office. So it may make sense to have Ms. Rios have a consultation with you. I think for right now, I'm going to have Ms. Rios represent you just for the narrow purpose of working through whether we set aside this warrant. Do you have surgery already scheduled or you're hoping to have surgery scheduled?
Yes, sir. On the 2nd, I go get a CT scan and an MRI to see how they're going to go into my neck and my leg. And yes, they're supposed to be on the 25th of March.
Okay. So it is scheduled. They're just going to do another check through the CT scan or MRI or both.
Yes, sir, because with my neck injury, it's a 50-50 chance that if it be a mistake, it could paralyze me. So this doctor is the 5th doctor that we're going to. The other doctors don't want to take the chance. So this Mr. Barber, he think he can go ahead on and take the chance and get me taken care of with all three of my injuries.
What was your job where this happened? Were you like a stunt guy?
I'm sorry. No, sir, I'm a commercial electrician, and what happened, I was on a ladder at 13 feet, and the guy who worked the night before installed the camera, and when I got ready to hook it up, he did not secure it correctly, and it fell on my head and knocked me out, and I fell 13 feet unconscious off the ladder.
Okay, that's never a good plan. I'm sorry that happened. Okay, and I'm looking at the case here. We're dealing with an allegation from February of 21. So we're now at the 5-year mark. Let me hear from the prosecutor to see if she's got a perspective on whether I should set aside the bench warrant now that we've got a good address, your fiance has shown up, and you've got this pending medical appointment. Ms. Smith?
Yes, Your Honor, at this time, the state doesn't oppose to setting aside the bench warrant.
Okay. Me neither. So your bond is from April of 2023. And I guess I'll just reinstate that bond. Hold on. Okay. Close that. The main condition was to stay away from Mr. Waddell, that's the alleged victim in the case, and to stay away from an address in Hapeville. Sounds like both those should be pretty easy if you're living out in Douglasville now. Does that still make sense?
Yes, sir, especially when I'm gonna be laying in the bed for the next year.
Right. Let me ask about that, because what we're probably not going to do is leave you alone for a whole year. Are the doctors saying that like literally you can't sit up for a year, or you just shouldn't go climb a ladder and have a camera fall on your head?
I'm sorry. Basically, when they go into my neck, it's my leg. Once they do my leg, I know my leg gonna take 6 months to heal because I ripped my ACL, my MCL, and my every ligament in my knee. It's gonna take just 6 months for that to heal. And for as my neck, they gotta go into the top of my neck and also the lower part of my neck. So they're probably gonna have to put a body brace on me and that's what the last doctor said. So I haven't talked to Mr. Barber. He haven't told me what he's gonna do, but they basically told me I need to prepare for at least a year of bedtime. Just to heal and learn me how to walk again.
Okay, that's a long time. Got it. Well, we'll figure out a way to move your case along. It may be that you appear virtually for things. You may appreciate breaking up the monotony of just laying there in bed.
I'm in a wheelchair right now, so I'm tired of the wheelchair. Oh God.
Okay, well, that'll be a switch from wheelchair to bed. All right, Ms. Smith, anything else on Mr. Reeves' case?
No, Your Honor.
Ms. Rios, how do you want to do this? Right now, you have helped Mr. Reeves by getting the bench warrant set aside, but I guess you and he need to have a conversation about representation.
Yes, it seems like it seems like he'd be happy to have me. So I think that will be, and I don't mind staying on the case. If he's not working, I'm sure he would qualify. But I do need a contact information because I want to be able to keep in touch with him about the case. Is there any way, I don't know what the best way to do that. Can someone type it in the chat? I don't know. I don't really want to broadcast his number on the internet.
How about this? I'm going to have his fiance write down, Deputy Gordon's going to give her a note card, and she's going to write down any phone numbers for herself or for Mr. Reeves, the home address, email, and then I'll get that to you, Ms. Rios.
Thank you.
And then once you've had a chance to consult, once you file an entry and a waiver of arraignment, we can get the case moving along.
Okay, sounds good.
All right, Mr. Reeves, any questions?
No, sir, and I would like to keep her as my lawyer if she accept me.
Okay, well, she's going to have to think about that one, but if she says yes, then you're in luck. So I don't know when I'll see you next. If it's not before your surgery, good luck with everything.
Okay, so I can go home to my little girl?
Well, you didn't tell me you had a little girl unless that's how you're referring to your fiance.
No, sir, I got a 2-year-old little girl that I keep telling, she's missing me and I keep telling them at work, so.
Got it. Nope, you're not going to be at work much longer. I'll sign some paperwork today. I cannot promise you that you'll get out before Monday. It may be Monday when they release you, okay?
Yes, sir.
All right, but then you can go home and be with your little girl and your big girl, and you need to stay out of trouble while you're on bond, okay?
I absolutely will. I give you my word.
Okay, all right. Good luck with things.
Thank you.
And thank you, medical ward.
No problem. Thank you.
Okay, we're going to do your other case.
Okay, so
You're leaving.
Amy here will replace me because I have to be at the jail.
Okay, that's fine. We're going to do, it's up to you. It's going to take 2 minutes. The only other thing we're doing is if you need to do the handoff, do the handoff.
I'll do the handoff. Yes.
It's position 7. Oh, you don't have the calendar. 2 North, booth 1. Is it, well, hold on, is it legible?
Yeah.
Okay, I just want to make sure we can read it.
Yeah.
All right, good luck with things.
Yes.
Yes.
So San Gampa is the middle of the keeping time. No sé.
Woo, look at that. Yeah,
Okay.
thanks.
All right, and also time.
Come on up.
Thank you. Remember the Redex, please.
Thank you. Are you Senor Gamba Mateus?
Yes, sir.
Excellent. You're up.
Where do you need to stand?
Where he was seated, just at defense counsel table, just taking that seat.
And so whenever you're ready, I just need a second to introduce myself to Mr. Gamba.
Why don't you do that? He's on the screen. So you just take a seat where he was. And then when you see yourself on the screen, you're in a good spot and you'll see your client on the screen. There you are.
Okay. Buenas tardes. Señor Gamba, ¿me escucha?
Sí, señora, buenas tardes, tengan todos. Dios los bendiga.
¿Me entiende bien?
Súper bien.
Entiende que yo soy la intérprete, voy a repetir todo, no soy su abogada, ¿correcto?
Ok. Sí, señora, muchas gracias.
He can hear me, he can understand me, and he knows I'm gonna repeat everything he says and I'm not his attorney.
Thank you for doing that.
Tengan buena tarde todos. Dios los bendiga.
¿Cómo?
Tengan buena tarde todos. Dios los bendiga.
Good afternoon to everyone.
Good afternoon, Senor Gamba Mateus.
Buenas tardes, señor Gamba Mateo.
I'm Judge McBurney, and we are going to talk about bond in your case.
Yo soy el juez McBurney y vamos a hablar en su caso acerca de una fianza.
This is 25 SC 005757.
Entonces, ese es el caso 25 SC 005757.
Mr. Gamba Mateus is represented by Ms. Rios.
El señor Sebastián Gama Mateo lo está representando la abogada Ríos.
And for today, the state is represented by Ms. Smith.
Y por ahora, por la audiencia de hoy, la señora Smith está de la Fiscalía representando al Estado.
Ms. Rios, tell me what you're hoping happens today.
Señora
Yes.
Ríos, dígame por favor qué es lo que usted está pidiendo para hoy.
Yes, Your Honor, I'm hoping that we can reduce to the lowest bond possible. Not sure that he can't afford hardly anything, maybe $100 possibly. He is, oh, should I wait for you to translate? I'm sorry.
Entonces estoy pidiendo que le rebaje la fianza lo más mínimo posible. Él casi no puede pagar nada. Estaba esperando que se lo pudiera rebajar inclusive hasta un mínimo de $100.
No, sí, pero.
This is the interpreter. Did somebody say something?
That's your client. Can you say that again?
I didn't see him say.
Oh, did
He
he?
wasn't talking. I don't know who was talking.
Oh, yeah, sorry. We had a cell phone that was on. I just cut that off. Okay.
Yeah, so Mr. Mateo Gambia Mateus is 31 years old. He has been in he lived in Sandy Springs for the last 4 years. He's from Colombia. He was doing roofing work. He has an immigration hold, and since November, I've been trying to reach out to the state to work this case out. I feel really bad because I've been coming to see him and he just like, I just want to take a plea. I want to work this out. So I've been trying to do that, but I haven't had any luck.
Okay, I'm going to pause you because the translator has a lot to say.
Entonces el señor tiene 31 años. Está viviendo en Sandy Springs. Hace 4 años que está aquí, que vive aquí, trabaja aquí. Es originalmente de Colombia, estaba trabajando haciendo techos, trabajaba en roofing. Sí tiene una orden de detención de inmigración. Desde noviembre que yo he estado tratando de negociar con la fiscalía, me siento muy mal porque no he podido conseguir ninguna oferta para resolver este caso. He estado tratando y yo lo voy a ver al señor y me dice, yo necesito salir de aquí, si me hacen una oferta yo me declaro culpable, lo que sea, pero una fianza, pero yo necesito salir de aquí y no he podido negociar con la fiscal todavía.
Was there more you wanted to add, Ms. Rios?
¿Quiere agregar algo, señora Ríos?
Not at this time, Your Honor. Just asking for the lowest bond possible, and hopefully soon we can have a resolution. I know it's been talking with the state right now. They're trying to get someone, reach out to someone that has the authority to resolve this case and talk to the victim. Hopefully the ball can get rolling now that this has been brought, now that we're having a bond hearing and everyone is aware.
Okay, before we transition to the state, I'll let this be translated.
Entonces, he estado negociando con la fiscalía. Lo que más quiero es que le rebajen la fianza o que me hagan una oferta para resolver este caso. Quisiera que la persona que tenga la autoridad para rebajarle la fianza nos ayudara a resolver esto, que hablaran con la víctima, que movieran el caso, que hicieran lo necesario para poder resolver esto, ya sea con una oferta que el señor puede aceptar o con una fianza.
Did you follow all that, Señor Gamba Mateus?
Señor Gamba Mateos, ¿usted entendió todo eso? ¿Está siguiendo el hilo de lo que está pidiendo su abogada?
Yes, Ms. Senator.
Yes, sir.
Thank you. We have someone with some authority here.
Judge, I'm not sure I have the authority on the reduction. However, I do have the updates.
Okay.
Entonces ya tenemos a alguien con cierta autoridad aquí. El señor fiscal dice, bueno, yo no sé si tengo toda la autoridad, pero sí le tengo algunas actualizaciones acerca del caso.
And I don't know that when you say reduction as in bond or as in charges, because I don't know that anyone was asking for charge reductions.
That was based upon Ms. Rios. I was interpreting Ms. Rios discussing about potential resolutions and moving things along based upon the offline conversation that we've been having.
Okay.
Entonces, cuando usted dice de reducir, ¿usted se refiere a reducir la fianza o reducir de una vez los cargos? El fiscal dice, no, o sea, ella en esta audiencia no pidió oficialmente una reducción de cargos, pero basado en las conversaciones que mi oficina ha tenido con la señora Ríos hasta ahora, yo entiendo que ella está buscando más bien resolver el caso.
We're at 7 months in custody and an ICE hold, is what I understand.
Yes, Your Honor.
Según lo que tengo entendido, lo que tenemos aquí ya son 7 meses de custodia y también una orden de detención de inmigración.
Judge, there had been a request from Ms. Rios of a potential misdemeanor resolution.
Entonces, la señora Ríos había pedido que le ofreciéramos algo para resolver esto basado en un delito menor, que lo redujeran a lo que en inglés se llama un misdemeanor.
Because this is a SVD case, it would also require the approval of someone in that chain of command. I did reach out to Ms. Peterson and advised her of the facts of this case.
Entonces, como esto es un delito que cae bajo la categoría de lo que le dicen SVD, que son delitos de naturaleza sexual, alguien de ese departamento tiene que autorizar cualquier reducción de cargos. Entonces, hablé con la señora Peterson, que ella sí tiene conocimiento del caso.
In addition to Ms. Peterson's approval or someone in that chain of command, we also would be wanting the victim's approval on a reduction for today.
Entonces, además de la aprobación de la señora Peterson, que es la persona que trabaja en el Departamento de Delitos Sexuales, también tendríamos que consultar con la supuesta víctima para poder finalizar una reducción de cargos.
The victim is on the Zoom, and I had an opportunity to speak to her in the hallway. That's why I just got up and left. She opposes a reduction for purposes at least of today.
La víctima está en esta llamada, está en el Zoom, por eso yo salí un momentito al pasillo para hablar con ella. En el día de hoy, ella se opone a una reducción de cargos.
So understanding that right now we're 0 for 2 as to what I would need to be able to do the reduction, I am comfortable at least offering a probated 5-year sentence, understanding the ICE hold, but that is not an exit ramp for today's bond proceedings.
Okay.
Entonces, dado que no tengo ni la aprobación de la señora esta del Departamento de Delitos Sexuales, ni tampoco la aprobación de la supuesta víctima, en este momento no estoy autorizado a rebajar los cargos a un delito menor. Lo máximo que puedo ofrecer hoy día sería una sentencia de 5 años. This is the interpreter, and you said probated.
5 years probation if he wishes to resolve today.
Entonces sería una sentencia de 5 años, que los 5 años serían probatorias, serían libertad condicional. No le están pidiendo esos 5 años de cárcel. Eso es lo máximo que puedo ofrecer hoy, pero entiendo que eso no es una solución final a lo que estaba pidiendo la abogada, que era una fianza para poder salir inmediatamente.
Ms. Rios, my thought is, based on what we've heard from Mr. Sperry, that you arrange for a time to speak with your client with an interpreter with you.
Entonces, basado en lo que está diciendo el fiscal, señora Ríos, lo que me parece que sería lo mejor es que usted pudiera tener una conversación privada con su cliente.
I sent an email to you and Ms. Nix indicating my willingness to take a plea anytime soon, should you to sort something out along the lines of what Mr. Sperry said.
Entonces, yo también hablé con la señora Nix y le expliqué a ella que yo estoy disponible para aceptar una declaración de culpable en cualquier momento, lo más pronto posible, si es que su cliente decide aceptar esta oferta y declararse culpable.
Fit that in during a lunch break or after trial or before, whenever you and Ms. Nix can do it.
Entonces, cuando usted y la señora Nix estén disponibles, yo lo puedo hacer en cualquier momento, en un descanso, a la hora del almuerzo, en cualquier momentito que el juez esté disponible, le puede aceptar esa declaración si usted decide hacer eso después de hablar con su abogado, su abogada.
You can continue to lobby for a reduction.
Usted puede seguir abogando y pidiendo una reducción.
But given that there is an ICE hold on Mr. Gamba Mateas,
pero dado el hecho que el señor Gamba Mateos tiene una orden de detención de inmigración,
changing the bond only risks our ability to resolve this case.
reducirle la fianza lo que hace en este momento es pone en riesgo la habilidad de la fiscalía de poder enjuiciar este caso.
Because we could lose him to federal custody.
Porque en ese caso lo perderíamos al señor, o sea, usted se iría en las manos del gobierno federal y la fiscalía de aquí de este condado ya no tendría acceso para hacerle un juicio.
I understand, Your Honor. Just so, Sebastian, so basically we have an offer of 5 years probation. I'm going to come and discuss that with you a little bit more. I might be on trial next week, but probably not. If I am not, hopefully we can resolve your case in the next 2 weeks.
Entonces, Sebastián, lo que están ofreciendo es, a cambio de una declaración de culpable, una sentencia de 5 años, pero bajo libertad condicional. No están pidiendo cárcel. Es posible que yo tenga un juicio pronto, pero voy a tratar de venir a verlo a usted en las próximas 2 semanas.
Yo sí quisiera decirle a mi abogado que me gustaría solucionar esto ahora mismo y yo me declararía culpable.
So I would like to say that I would really like to take responsibility and take care of this right now, if you're willing to accept a guilty plea. Judge, this is the interpreter. I have nothing, nobody else, no other courts waiting for me right now. I can interpret for them in a breakout room, if that would help.
Ms. Rios, would you prefer to speak with Mr. Gamba Mateas in a breakout room now, or do you think it's more important that you have a sit down with him to discuss any potential immigration or removal implications of a misdemeanor versus a felony?
Entonces, señora Ríos, señora abogada, la intérprete está disponible si usted quiere hablar en privado con su cliente ahora. Usted tiene que decidir como la experta, como la abogada de él, si es mejor resolver esto ya o si usted quiere hablar con él acerca de las posibles consecuencias y otras opciones y consecuencias de inmigración. La abogada va a decidir cómo quiere manejarlo.
I honestly would prefer that, but it's up to him. I have seen Mr. Mateas several times and we've talked about it, and he's every time been eager that he wants to resolve the case. So I don't want to make the decision that we have to put it off longer if he's really wanting to take it today.
Entonces, yo he hablado varias veces con el señor Gamba Mateos y él siempre me ha dicho que quiere resolver esto lo más pronto posible. Entonces, no quiero postergarlo si él está decidido y no es necesario.
So we're talking about today versus maybe in the next week or so. Do you have a preference, Mr. Gamba Mateus?
Entonces, estamos hablando de una diferencia de tal vez resolverlo hoy, si usted decide declararse culpable, tal vez hacerlo hoy o posiblemente en 1 o 2 semanas. Usted, señor Gamba Mateos, ¿qué prefiere?
Yo quisiera arreglarlo el día de hoy.
I would like to take care of this today.
Okay. Then I guess if you have a phone, I can give you the Zoom info. You could go into the jury room, and once you've logged on, I could get the three of you into a breakout. Does that work?
Yes, sir.
I appreciate you offering that up.
So you need my phone number or my email?
I'm going to email to you the Zoom information.
Okay.
So do you have county email or
No, sir.
secret email?
I'm a contractor. But it's my business. I
Okay,
can say it whenever you're ready.
I'm ready.
It's Amy Interprets, AMY Interprets
Yeah.
with an S @gmail.com.
All right, the Zoom link is coming your way in a moment. This is today, that's today.
And Judge, just to lay out the full recommendation, since they'll be talking and conveying that, it would be the 5 years probation and no contact with the victim. However, I think all parties are aware that with this felony conviction, what will take place.
Sure. I'll probably say stay away from the McDonald's too.
Yes.
Me dice,
Entonces, el juez me está mandando a mí un enlace para yo poder meterme de una forma privada a esta llamada. Nos van a poner en una sala privada para que hablemos usted y su abogada. Yo le interpreto. Cuando la decisión esté lista, entonces el fiscal lo que me está diciendo es que si vamos a hablar acerca de esto con su abogada, que lo que están pidiendo son 5 años de libertad condicional, que es probatoria, no contacto con la supuesta víctima y va a haber una orden, una condición de no acercarse al McDonald's donde pasó todo esto.
ok, sí, señor.
Yes, sir.
All right, I'll wait to see you on Zoom. When I do, we'll get the three of you into the breakout room.
Okay, and I have the link.
Great.
So can you tell me again where I'm gonna go?
There's a jury room right through that door.
Okay.
That way you can speak freely and we'll be able to knock out a few other things.
Okay.
So if you want to just, I think it pushes.
And then once I log on here, the host will be able to put us 3 in a breakout.
I'm the host. So yes, I hope so. We'll find out. Ms. Wood, you ready to do Mr. Ector?
Yes, Judge.
I don't know if the interpreter's on. You want to check and find out what she's listed as, please?
She's signing on.
She's signing on now? Okay. Are you on?
No, sir, it just searches and searches. I can call the attorney.
Well, but you can't really do translation. What's searching? I don't know what's searching.
Just, I have no signal back here.
Wi-Fi.
Judge, did you want to maybe do the breakout with me and I can give her my computer?
What we're going to do is do this plea not today.
Yeah.
So we'll do it another day.
I'd be glad to interpret for her since they don't have ready access for interpreters. They can only do that part.
Okay, well, she's not here either, and stuff is piling up. So if you can just pop back in here and let Mr. Gamba Benteas know we're not going to take care of this today. Whoop, we're getting Mr. Ector mid-lunch.
Yeah, it just won't connect. I don't have a signal back.
Okay, well, if you can just get back to your spot there, we'll let Mr. Gamba Mateus know. It'll be very soon. Mr. Gamba Mateus?
Señor Gamba Mateos, yes, sir.
We're going to need to bring you back here probably in person.
Lo que vamos a tener que hacer es traerlo aquí otro día en persona.
Late next week or early the week after for the plea.
Va a ser, ojalá la semana que viene, es que no pude conectar, no funciona el enlace aquí en este cuarto.
Mister, yo no tengo ningún problema en hablar por este medio con mi abogada, no hay ningún problema.
I have no problem just talking here in public.
I know, but we
with
can't.
my attorney.
That makes us stop everything we're doing, and we can't stop everything we're doing. So I'm going to arrange for Ms. Rios to meet with you. It's not a public-private thing. We can't have that conversation. You can't have that conversation, and then we're still doing business.
El problema es no es cuestión de privacidad, sino que tengo un calendario lleno. Entonces se me va el día y necesito seguir adelante con los otros abogados y los otros casos. Entonces voy a hacer una cita y la señora Ríos va a hacer una cita para ir a verlo lo más pronto posible.
Sebastian, just 7 to 10 more days. Just 7 to 10 more days. Just hang in there, okay?
Son 7 días más, máximo 10 días. Lo voy a ir a ver lo más pronto posible, así que un poquito de paciencia, por favor. Y yo entiendo, pero voy a ir a verlo lo más pronto posible.
Okay.
I will see you soon.
Entonces nos vemos pronto.
Okay, sí, señor. Gracias.
Okay, you're welcome. Bye-bye.
Thank you.
All right, let's turn to Mr. Ector. Mr. Ector, you okay going forward even though we're interrupting your lunch?
Yes, go ahead, sir.
Okay. Well, we're going to get on the record in your case. It's 25 SC 007-492. And Mr. Ector, Ms. Wood tells me you're ready to enter a plea. Is that correct?
Yes, sir.
All right. Well, Ms. Smith, and we're going to need you to move the camera or yourself, Ms. Smith, a little bit so Mr. Ector can see you. Ms. Smith is going to put you under oath and then ask you questions about your case. You need to answer those questions truthfully and completely. You also need to let me know if you've got any questions. Will you do that?
Yes, sir.
Okay, Ms. Smith.
Mr. Ector, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Ma'am?
Please state your true, correct, and legal name for the court.
Bruce Leonard Ector.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 53 years old, and I went all the way up to the 12th grade.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So waived.
Mr. Ector, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
We're not.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 90 days with the balance probated?
Yes.
Are you aware that the court does not have to accept that recommendation and can sentence you to the maximum on each charge and can run those sentences consecutively, meaning one after another?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Are you currently on probation?
No.
And are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of both of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence and other witnesses of your own, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied your client understands that these are the rights that they'll be waiving by entering this guilty plea?
I am.
Mr. Ector, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No.
As to indictment number 25 SC 007492, how do you plead to count 1, aggravated assault, and count 2, aggravated battery?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Ma'am?
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there's some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. Do you also understand that this has to occur within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this plea?
Yes, ma'am.
Okay, thank you, Mr. Ector. Your Honor, if this case were to proceed to trial, the state would show that on August 13th, 2025, officers responded to 2033 Joseph E. Boone Boulevard, that's in Fulton County. When the officers got there, they talked to the victim, Mr. Watts, who stated that the defendant, they got into a verbal argument, and the defendant picked up a 2x4 that had spikes on it and hit the victim in his face with it. At that time, Mr. Ector was not on the scene, so the officers were not able to talk to him initially. However, they were called back to the scene on October 7th, 2025, and the victim told them that the defendant was at the location at that time. The officer spoke with the defendant at that time, who was arrested for these charges and charged accordingly. And those are the facts of the case regarding the negotiated plea between the state and defense. We've agreed to an offer of 5 years to serve 90 days with the balance probated. As far as special conditions, the state is recommending an anger management course for the defendant to stay away from the incident location, for there to be no contact with the victim, and for the defendant to complete 30 hours of community service. And that is all from the state, Your Honor.
The indictment suggests Mr. Watts, that's the gentleman who's the victim in the case, something bad happened to his nose. Do you know how he's doing, the status of his recovery, and his thoughts about this outcome?
Yes, Your Honor. Well, no, Your Honor. We did reach out and tried to reach out to the victim. We did a victim locate. We were not able to locate the victim and ask him about his injuries.
Okay. This address on Joseph E. Boone, do you know what's there?
I'm not sure. Let me look that up. I'm not sure what's there.
Okay, while you're looking it up, let me find out from Ms. Stallworth, criminal history information on Mr. Ector.
Yes, Your Honor. Excuse me. He has 34 cycles. There are 2 FTAs, 2018 from the city of Atlanta, 2012, also from the city. There's a 2016 conviction from Clayton County for criminal trespass and terroristic threats and acts, and there are 7 convictions outside of the 10-year period. Nothing further.
What's his most recent arrest?
Give me just a minute. I think it was at 2018 from the city.
That's on 10% only around. Okay. So they could like, oh, we should go. If Jane got
Clayton County in 2019 for a probation violation.
Okay, and then obviously this, but between then, 2019 and this case, there were no cycles.
Give me just a moment to check make sure. That's correct.
Okay, and then you said there were 7 convictions, but they are all more than 10 years old.
Yes, 05, 03, 02, 2000, 98, 93, and 92.
Way back when. Okay, great. Thank you so much.
You're welcome.
Ms. Wood.
Thank you, Judge. So Mr. Ector has already done the 90 days. He's actually been in 107 days. He's a lifelong resident of Atlanta. I have spoken to his aunt. He'll be living with her in the area, and he is hooked up with Tin Park Place. He gets his medication there. So we're just asking that you accept the state's recommendation in this case.
All right.
Yeah.
Yes, Ms. Smith.
That location is a true worship fellowship church.
Church.
Yes.
Thank you. Mr. Ector, were you a member of the church where this happened, or was that a place where you and Mr. Watts hung out, or what's your connection to that address?
That's the place where they feed the homeless folks at Monday through Friday from 9 in the morning to 12 o'clock.
And were you there working, or were you there eating?
Eating.
Okay, understood. Do you have any questions, Mr. Ector, about anything anyone has said so far about you or your case?
No, man, no, sir.
The gentleman that got hit by the 2x4, that you hit with the 2x4, Mr. Watts, was he someone you knew?
Yes.
What was the beef? What were you guys arguing about?
Well, the true story is that the man had hit me about 3-4 times in my face before I even hit him one time with the stick.
Okay.
I never got to tell nobody, but Your Honor, I was struck in my face to my eye was swollen and everything 3-4 times. And the dude at the church named T and the girl named T, they would tell you that he came around that curve at me again, and that's when I hit him with the stick. Cause sitting there, I would have never hit that man with no stick.
Okay, so I hear you. There's as an element of self-defense to this. What were you and Mr. Watts upset with each other about?
Cause he thought I had got his jacket, and
Okay.
I was like, the jacket that I was laying on the ground was an old beat up jacket. He thought I stole the jacket, and I was like, nah, I gave him the jacket. Here, man, get the jacket back. I don't want none of it. Nothing eat you on.
Mr. Ector, when you get out, you're going to get out soon. You'll get out early next week, probably. Are you going to be able to go to a different place for meals? Because you really can't go back to this church anymore.
Listen, I know I'm not going back to that church no more, period.
Okay.
Even from that, I ain't even trying to see him. I don't want to see him because he gonna hit the crazy move again.
Okay. Well, it sounds like you've got a good plan in place. Mr. Ector, I find there's a factual basis for your plea, and that your plea is what we call knowing and voluntary, meaning you've understood what we've been talking about, and that you've decided that taking this plea is the right thing for you to do. Is that a fair statement?
Yes, sir.
All right, then I'll accept your plea. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Smith?
Yes, Judge.
And Mr. Ector, can someone in my office sign the indictment for you? Just indicating your guilty plea. Is that okay if we do that?
Yes.
Okay. I'm going to sentence you on count 1 to 5 years to serve 3 months with the balance on probation. Count 2 is going to be that same sentence. So it's a total of 3 months in custody, followed by 4 years and 9 months on probation. Special condition of probation number 1 is you stay away from the church on Joseph E. Boone. Even though they were good to you, you got to go to a different place for meals.
Okay.
Special condition number 2 is you stay away from Mr. Watts.
Okay.
I'm going to ask that the folks with probation help you find an anger management class. And you're going to do 30 hours, 30 hours of community service. And you need to do those in the first 6 months of your probation.
Okay.
I'm going to ask that probation assign you a mental health probation officer, someone who's going to help you coordinate with 10 Park Place and do the things you know you want to do in connection with that. And I'm going to set a behavioral incentive date of February 21st, 2029. And what that means is that if you've done well for the first 3 years of your probation, no issues, no arrests, no hitting someone with a 2x4, then we can end this early and you can be going about your business without probation in the mix.
Okay. Thank you, sir.
Well, you're welcome. Any questions about that?
No, sir.
Ms. Wood, anything else on behalf of Mr. Ector?
No, Your Honor, thank you.
Ms. Smith, on behalf of the state?
Please, Your Honor.
Yes, sir.
Can I ask you one thing?
You may.
I want to know, I'm just asking because I'm still kind of lost. I don't know what to say.
How much what is going to be?
No, I ain't asking on how much then it's going to be. I want to know when I'll be released.
Oh, you should get out Monday or Tuesday.
Okay.
Because you have already done 3 months. I sentenced you to give you credit for the time you've done. But hey, don't run away quite yet. Ms. Simpson, do you need to give Mr. Ector some reporting instructions?
Yes, Judge. Mr. Ector, you need to report.
Whoops, I hit the wrong button and I muted you. It's not personal. I was trying to get you big on the screen. There you go. If you would unmute yourself, all two of you. There you go.
Can you hear me?
Yep, we're good.
Mr. Ector, you need to report to the Atlanta Probation Office. That is 276 Memorial Drive. That's about 5 minutes from where you are. You need to report there within the first 2 days after you get out.
Look, you said that out Memorial Drive or Memorial?
It's 276 Memorial Drive.
That's in Decatur.
Nope. It's right here downtown. Mr. Ector's not here in court, so it's actually pretty far from the jail, but it's about 2 blocks from the courthouse, right downtown. Like if you get to the, where the Greyhound bus station is and places like that, they're all about 2 blocks from each other.
Okay. Well, thank you.
No problem.
Okay.
Nothing further, Judge.
All right. Thanks, everyone. Mr. Ector, you're good to go. You'll get out Monday or Tuesday, okay?
Okay.
Bye-bye. All right, we need to knock out AC/DC. And that is...
Mr. Richardson, Judge.
Yep. And that's Ms. Wood and Ms. Smith. So we got everyone we need. All right. What are we doing, Ms. Wood? I'll get us on the record in a moment. What are we doing with Mr. Richardson?
Non-negotiated stipulation.
Okay. Let's get on the record. This is position 12, State versus Orion Richardson, 25 SC 004592. And Mr. Richardson, I've got your warrant right here. I signed a warrant for your arrest in connection with probation in October of last year. And the allegation is that after you pled, you were released. You were told to report to the office within 48 hours. You may have heard Ms. Simpson just tell Mr. Ector that. And you didn't, and no one could find you. So you've done what we call absconding. You were supposed to plug in with probation as the first step of your sentence, and you didn't. You've now been sitting in jail for a while, and we're going to work through that. Ms. Wood is...
I've emailed you an updated petition.
Oh, it gets interesting. Let's see. Here we go. Oh, does Ms. Wood know about the updated petition?
Yes, Judge.
Okay. So not only did you not appear, but you got arrested for new charges: theft by receiving, stolen property. Oh, goodness. You were sounds like maybe driving someone else's car real dangerously, and you didn't report. That's now kind of a small deal in light of the big deal of all this other stuff. So, Ms. Wood, now that I understand more, what's the status of these charges?
It's unindicted, Judge.
Okay, thank you. So Ms. Wood, is Mr. Richardson stipulating to the arrest?
Yes, Judge, stipulating to the arrest only.
Okay, is he denying that he failed to report or he couldn't report because he got locked up?
Yeah, yes, so I'm sorry. Stipulating to the new arrest and then also to the technical violation as well, Judge.
Okay, well, tell me your recommendation, what's going on with Mr. Richardson, and then I'll hear from Ms. Smith.
Your Honor, Mr. Richardson is 36 years old. He's a lifelong resident of Atlanta. There was a short turnaround between his release from the original case and this arrest, so he had not yet gotten back on his feet, so he was unemployed at the time. He does have a good stable address on file with probation. He's asking the court to consider revoking 4 months. He's been in 127 days and then reinstate to probation.
All right, let me see, he's got a little less than 3.5 years remaining on his sentence that he had just started. Okay, Ms. Smith.
Yes, Your Honor. In this case, the state will be asking to revoke 18 months and to reinstate the balance, mostly because the new offense happened just a month after he took the plea for the underlying charge, and also that those new charges are very similar to the underlying charges he took the plea for. For example, theft by receiving, fleeing and eluding, and reckless driving are 3 of the new charges that are the same as the one that he already pled guilty to. So because of his high risk of reoffending, the state would ask for, or the fact that he reoffended just a month after taking the plea, the state is going to be asking to revoke 18 months and to reinstate the balance in this case.
Okay. Ms. Simpson, does the Department of Community Supervision have a third view?
Judge, I conveyed to Ms. Smith as well as Ms. Wood that my recommendation would be to revoke a year and to reinstate. However, I would also take in consideration a drug court referral.
Okay, and tell me what's behind the drug court referral.
Given that, as Ms. Smith stated, the new charges are pretty much replicated of the current charges he's already on probation for. I just thought that it would, if we could kind of jump ahead of the possibility of him reoffending by taking care of some substance abuse issues, that would, the hope is that it would kind of help resolve the reoffending part.
Got it. Okay. All right, Ms. Wood, anything you want to say in closing?
No, Your Honor.
Okay. Mr. Richardson, anything you want to add?
I was just, yes, sir. Well, when I came here, it's a long story. I don't want to talk about it. But the judge at preliminary gave me a signature bond, and he gave me a signature bond for the charges we discussed, and he was basically saying that, you know, being that I had no FTAs and that he understood my situation, that they should reinstate my probation. I get another chance, and then he was saying this will be my last chance. That's why they gave me the signature bond on my first. Because initially, yes, it was a technical violation initially. I did report 2 times when I went up there to do the intake. My initial officer, the initial probation officer was not there, Judge McBurney. Then I had to come back again until they gave me a date to come back for the I was actually supposed to be there because it was referring to community service. So they had my paperwork messed up, and then after that they gave me a later date, and then that's when this actually occurred. So when this occurred and I went to court, this is what the judge was basically discussing with me, saying that the judge or whoever was referring to you, that I should get another chance, and this will be my last chance. That's why they gave me the signature bond for my charges. I received a signature bond October 21st for my charges. So he was like, okay, well, when you go to probation revocation, do that petition. The first petition was the technical violation. And on the run, I caught the new charges. He said the judge, you know, he was just saying that the judge should possibly recommend, you know, reinstating probation, and this would be my last chance if I mess up.
Okay, well, that's not quite what's in the records. In October, you were in front of Judge Oliver, and she set a $37,000 bond. For a few of the counts, it was UJR, but the total bond was $37,000. Then you waived your preliminary hearing, and in November, Judge Kura lowered your bond to $28,000. So there are pieces of it that are signature. You were able to sign for driving without a license, but for the stolen car, the damage to property, the reckless drive. In fact, the reckless driving is a $10,000 bond. So they lit you up, and I understand why, because you got those charges so soon after pleading to very similar charges. Now, I'm not trying to contradict whatever you think those judges said to you. You were there, I wasn't, but the paperwork doesn't quite bear out what you were sharing with me. But in some ways, it doesn't matter. We don't need to go around and around on that, because those judges were fulfilling a different role, and they set a bond. And I'm the one who sentenced you not all that long ago, and you said, Judge, I'm gonna be a different guy. And just a few weeks later, we had almost the same thing happen, which is dangerous to you. It's dangerous to everyone else on the road, as you are trying not to get caught by the police, who are simply trying to pull you over. So, given your stipulation to the new charges, I am going to revoke 12 months or 1 year of your probation, reinstate the balance. If in the interim, your lawyer and the prosecutor can come to some agreement and want to get the case accused, I'm happy to have it green sheeted to me, since I've heard about it. But otherwise, those charges will go in whatever direction they go. And we'll see what happens. But the judge who gets that case will obviously know that you have already had some consequences for the new arrest in terms of what happened with the revocation. I'm open to drug court. I don't know that it's necessarily something that fits for you, that not what shows up in any of the charges, but we can revisit that at the appropriate time. Ms. Smith, any? Yes, Mr. Richardson?
So you revoke a year, so the case will be, what does that mean? The case will be over with, as far as, like, what does that mean? I gotta go to prison or county time?
So I'll break that down into two things. So your older case, it's not very old, but your older case, the one you already pled to, I just revoked a year of your probation. So you're going to do a year. You will go into state custody because that revocation is more than 6 months. And your new charges, I suspect, will turn into an indictment during the course of that year. So it'll be assigned to a judge, and that judge is going to learn from your lawyer, hey, you know, Mr. Richardson's in custody. They'll try to connect you via Zoom from wherever you are, and you may well be able to resolve these new charges while you are working on your revocation in these slightly older, very similar charges. Did that answer your question?
Yeah, so basically what you're saying is, while I'm locked up in prison, down the road, the new charges, I go to court from while I'm in state custody, and y'all will work that out and resolving new charges.
Right, but you, of course, will be in the mix. Your lawyer will reach out to you, and your lawyer will give you her advice. Hey, you know what? You should just appear virtually. You could insist on, I want to be there in person. They could get you on the van and bring you back up here. Very few people choose to do that because you can get plugged in with resources and programs, and I come back to Rice Street. But you and your lawyer will talk about where you will be while you are working on the new charges. But I suspect the new charges will be indicted, and you'll get assigned to a judge, and you'll get a lawyer while you are dealing with this revocation. And you could choose to work it out if you think it's a fair outcome while you are down in DOC, so you don't have to come back to Rice Street or ACDC to deal with the new charges. But that's your call. No one forces it on you. You and your lawyer will talk about that.
Okay, so do I get accredited for all the days that I've been in here since October 7th? get credit for all the days?
You're not going to get credit for that. That's why I didn't revoke 18 months. So I revoked less than what the state recommended because in my mind, I'm thinking 18 months isn't a bad recommendation, but I can't give you credit for time served. So I just need to shrink the amount of the revocation. So instead of revoking 18 months, and then you would not get credit, I revoked less than 18 months knowing that you had already done a little more than 3 months. So what you could view it is that I revoked 15 months. But I don't want to say that because if I revoke 15 months on, I just said it, but that's not what your order is going to show because you wouldn't get credit for the 3 you did. So I backed the 3 out and I'm revoking it for 12 months. Okay?
Okay.
All right. Ms. Wood, anything else?
No, Judge, thank you.
You're welcome. Ms. Smith, anything else?
No, Judge.
All right. Good luck, Mr. Richardson.
All right, waiting to get on the bus then, right?
Say that?
Waiting for the bus then, the Bluebird.
You are waiting on the bus. Exactly.
All right.
All right. Take care.
All right.
All right. That is it for ACDC. Thank you, ACDC. Three, two. Melvin Johnson, can you wave your hand? Excellent. All right. All right, Mr. Johnson, I got you unmuted now. Good afternoon. How you doing?
I'm great.
I appreciate your patience. This is going to be pretty quick. Ms. Wood, your lawyer, has already filed a speedy trial demand, meaning your case is moving at hyper speed. It's going to be on a trial calendar real soon. But this is the first time I'm seeing you, and so we actually have to handle your arraignment. I'm assuming it's a waiver of arraignment, Ms. Wood?
Yes, Judge, I've already filed that.
Excellent. So Ms. Wood entered a plea of not guilty on your behalf. More importantly, she filed this demand for a speedy trial, which was timely, which means your case is going to be on the next trial calendar, which is a March trial calendar. So the state is running fast to get ready. Presumably you and Ms. Wood are ready because you asked for a speedy trial. And that's where we are. Your lawyer will be getting discovery soon. If she doesn't already have it, she will meet with you to talk about that discovery. And then you guys will make a plan. Do you have any questions about anything I just said?
Yeah, I got discovery, and I'm trying to figure out where the activated salt come from.
We'll talk about it. Don't.
That's probably one reason why Ms. Wood filed a speedy trial demand. If you're trying to figure out what the heck did these charges come from, that may well be why Ms. Wood is saying, let's go. Let's get in front of a jury. And I want to tell you, you may not have a trial. It may be that your lawyer and the prosecution reach some negotiation that you're comfortable with and the state is comfortable with, and then we take a plea. But what your lawyer has done, presumably with your consent, is to greatly accelerate that process. So whatever the outcome of your case is, trial or plea, it's going to be in the coming weeks rather than the coming months. Okay? Anything else?
No problem.
Ms. Smith, I know you're filling in for Ms. Willingham for this. Anything from the state?
No, Your Honor.
All right, Ms. Wood, anything else?
No, Judge, thank you.
Well, I will see you soon, Mr. Johnson, either for a plea or for a trial, okay?
Okay.
Bye-bye. Don't know, is the South Annex on yet?
Yeah, and I'm still waiting on them to come. I'm calling again though.
Okay, no problem. We'll come back to Mr. Price. We're going to turn to Mr. Williams now, 5 North, booth 4. Hey, Mr. Williams, can you hear me?
Yes, sir.
Great. Hello, Mr. Wallach.
Good afternoon, Judge.
Ms. Smith, are you handling this for Ms. Nix?
Yes.
Okay, great. Thank you for doing that. Let's get on the record. This is 25 SC 005928, State versus Stacy Williams. Mr. Williams hails all the way from Arizona. He is here in custody. His lawyer, Mr. Wallach, wants to revisit the question of bond. I had denied bond because I received information that we all discussed, meaning lawyers and I, from DFACS about a call reporting alleged misconduct by the alleged victim in this case. And that call originated from an area code that is where Mr. Williams and his friends and family are. The state had brought that to my attention as an area of concern in terms of witness, victim harassment, tampering, et cetera. It took a few tries processing the DFACS records, as in just trying to understand what they were saying, because ultimately they closed out the allegation. But finally, they pointed me to, here is the phone number from which the original allegation of parental misconduct came. And that's a phone number with an area code that is special in this case because it is Mr. Williams's area code. And to me, that was sufficient reason to say, you know what, Mr. Williams, you're going to stay put. We're going to leave this alleged victim alone until we can sort this case out. I just want to set the stage for why bond was denied. Mr. Wallach, I will now let you take it forward.
All right, thank you, Your Honor. Let me first just say that Miss Trailer, Mr. Williams's wife, was on. She may have had to drop because of traveling and with her kids.
I'm still here.
Oh,
I'm
she is
still
still here. Okay. She is present, Your Honor.
Great.
This, as the court summarizes, where we were last time, and it may just be more semantics, but I would view this more as bond hearing part 2 rather than reconsideration, because the information that the court got and ultimately denied bond, this is the first opportunity that I've had to address that.
Mm-hmm.
In terms of my understanding is from what the court summarized of what occurred and what we know, there was a call to Ms. Little, the complaining witness, threatening that if she did not seek to dismiss charges against Mr. Williams, that person would notify DFACS, and there was indeed a call that was made into DFACS. What we know about that based on the court's further investigation and based on what I've now learned from the discovery is that the calls were by a female, both to Miss Little as well as to DFACS. That Miss Little thought it might be, but wasn't sure, Mr. Williams's mother, and that the calls were made in March. What that means and what I would ask the court to take from that is, one, it was not Mr. Williams directly. As the court's aware and as accompanied my supplemental motion for bond, there's an affidavit from both Mr. Williams as well as from Ms. Trailer. Mr. Williams did not make those calls. He's not a female. Mr. Williams also was not aware of that, did not indirectly request that. There is nothing that I'm aware of, at least from Miss Little and what she reported to the state or law enforcement, as well as what the court found out, that would indicate that Mr. Williams was aware or directly in some capacity requested or directed somebody to make that call or that threat. There's also an affidavit that was provided from Ms. Trailer, Mr. Williams' wife, that she was unaware of it, that she, to the best of her knowledge, Mr. Williams was unaware of it, and that there was no indirect contact from them. The other piece that we know from this is it's isolated to March. There have been no other calls, no other threats, no other indications of any kind, no improper communications of any kind that any of us are aware of. At the time in March, Mr. Williams had not been arrested and thus was not under any specific bond or court conditions. Doesn't make what occurred okay, but in the sense of it wasn't as if he was violating any court order. I think that what we know from this is that somebody connected to Mr. Williams perhaps had good intentions, but was extremely misguided in doing that. But it was not Mr. Williams.
What would the good intentions be of threatening the alleged victim and then it sounds like providing false information to DFACS? I'm trying to process the good intention part, unless you're looking through a very narrow lens of this may help my husband, brother, son, whatever the connection is.
Yeah, I just meant that in the sense of I don't think they meant it to harm Mr. Williams. And I'm only just assuming, Judge, but I assume they did it in the sense of, this would help him in some way. Obviously not. Mr. Williams has been sitting in custody. The court did not openly state that the court was going to grant bond at the end of at the last hearing before we got to this issue. Although the court did seem to indicate it was inclined to, or at least considering that. Regardless, Mr. Williams has been in custody since that hearing, which was in November. I say all of that in terms of the fact that it was not him directly or indirectly and isolated to March, not to say that it didn't occur, not to say that it was appropriate, but to say that there are conditions that can be set that could reasonably ensure that it would not be a concern in terms of contacting Miss Little, intimidating of witnesses or whatnot. And that would be obviously not only just placing what would be a normal condition of no contact, but obviously at this point, Mr. Williams, as well as anybody associated with him, has a very good understanding of how wrong that was, what occurred in March. I think is what we discussed in November. Mr. Williams would comply with any other conditions, including electronic monitoring. What we also know is in this case is, and this is what I've included in my filings since the last hearing, is Miss Little is not shy about contacting law enforcement if she needs to. In this instance, not only did Miss Little report this to the lead investigator, APD investigator Furcorn, but at Furcorn's direction, she reported it to Rockdale Police Department because it had occurred. She was present in Rockdale when she got a call. And there's a report from there that was made. Miss Little has also, within the last year, within 2025, contacted law enforcement regarding harassment by a prior boyfriend and child's father on 2 occasions, and contacted law enforcement regarding harassment or property damage by a mother of a child, girlfriend of what she referred to as her spouse. In addition to that, she also spoke with law enforcement regarding an incident in September of 2025 that resulted in her own arrest for aggravated assault in Walton County. So Ms. Little is not shy about contacting law enforcement or making it known if she feels that there's an issue. I think with all of that in mind, and where the court was in terms of Mr. Williams prior to the concern of intimidating a witness, that he is a good candidate for bond, that there are conditions that could be placed upon him that intimidating a witness would not be a concern, Your Honor. I'm happy to go backwards and talk more about Mr. Williams' history as we did in November. I know the court usually takes good notes, and obviously the court resuscitated the summary pretty quickly. So I will only do that if the court needs me to.
No, I'm good on that information. Let me hear a little bit from Ms. Smith, unless there was more you wanted to add about anything else. Let me ask you one question, and then I'll pivot to Ms. Smith. You have now several times, Mr. Wallach, asked to extend deadlines. And I certainly want to give you more time, but I'm less interested in giving you more time when, one, your client's in custody, but two, if I end up changing things, and I don't know that I will, I won't want to slow things down because he's out in Arizona not in custody. So can you help me understand why you need more time to wrap up the discovery phase of this case?
Sure, Your Honor, and I appreciate the court bringing that up based on that motion that I filed. So the court's scheduling order requires that both the state and the defense provide all discovery at the same time. And I'm very sensitive to not wanting to be in a position where I come across information a month, 3 months, 6 months from now, at whatever point before trial or before resolution of the case, where it is after that discovery deadline. So I can state in my place that I have provided the state with anything I have at this time, but my concern is at this time, what I don't know yet. And unlike the state, which I use broadly because it includes law enforcement under discovery statutes, that begins their investigation at the time that the incident occurs. From the defense perspective, it starts much later. I mean, obviously not until I'm retained in my situation, and oftentimes not until we get discovery from the state can we begin to go look and see what else that we may need. So if the court's position is, essentially if the state or defense hasn't provided something by that discovery date, by that discovery deadline, and therefore it's not going to come in at trial, I need an extension. If the court's position is, if you have something and you haven't provided it at that deadline, it applies, but it doesn't apply to what you yet don't have, then that's a different situation.
It's the latter. If you're sitting on something and you don't hand it over, and then it's the eve of trial, and you say, "Oh, look at this thumb drive," and then you're candid and say, "I've had this thumb drive for 6 months," then you're not using it at trial. But if 2 weeks before trial, the state were to find some DNA, you might ask for a continuance. I certainly give it to you, but I wouldn't say that's bad faith on the state's part because, assuming they can make a sufficient showing, we didn't test this cup that was in the hotel room until recently. We didn't realize there was a cup. The detective said, "Oh, I forgot to show you this evidence bag." Then we might need to delay things, but it wouldn't be excluded if you make a good faith showing that you simply didn't have it and didn't know to ask for it earlier. So if you are in the posture of having handed over everything you've got, then I think we should continue to move the case forward, knowing that if you do come across something a month from now, as long as you hand it over as soon as you get it, then it's not going to be excluded. Either we do a continuance or the state has to roll with the fact that they got it a little bit after the deadline. Happens all the time.
No, I understand, Judge. Like I said, I'm just being hypersensitive to that because the last thing I want is to have my client in a position where we've done an investigation, we have found what might even be exculpatory evidence, but we had this way earlier deadline and therefore we can't use it.
Yep.
And just to point out in terms of making this motion, especially if my client's in custody, I have no reason to want to delay the case. Mr. Williams has been in custody, so I certainly am not asking for delay for the sake of delay. It's very much the opposite. If he's in custody, I want the case to move forward, and my preparation is going forward whether he's in custody on bond. I understand the court's concerned, and if he is on bond, the court wants the case to move forward. And the court's concerned that if he's in custody, the court wants the case to move forward. So,
even more so, exactly. I mean,
certainly not based on, well, this way I can drag things out and he's going to be on bond and we can keep things moving. It's quite the opposite. I mean, at this point, he's in custody, and I'm just making that request because I need to be effective in representing him.
Okay, got it. Thank you for flagging that. Ms. Smith.
Yes, Your Honor. In this case, the state will be asking for the bond to remain to deny bond in this case for two main reasons. The first one, which we already talked about, but the significant risk of intimidating the witnesses. I do understand that defense is saying that the call was made by a female. However, we all know that witness intimidation can be directly or indirectly, and there's no evidence to show that the defendant here directed the female to call DFACS or to make that report. However, we do know that it came from an area code where the defendant and his relatives stay. So because we don't have any evidence or proof that this direction or this call was made alone or merely because someone took it upon themselves to do it on the benefit of a relative, the state doesn't believe that that shows a lack of responsibility from the defendant reaching out to the defendant. The defendant reaching out to the victim, whether that's directly or indirectly. Also, in this case, we do believe that since the defendant has no ties to the community, that there is a risk that he may flee and may not show up for the following proceedings regarding this case. So because we still do believe that there is a risk of significant witness intimidation because of those reports that were made and also the calls that were made to the victim's family business and things of that sort, the state does believe that the bond should remain denied at this point.
Okay. I don't know if Ms. Little is on the call or if she's provided any information to Ms. Nix and thus to you. Anything on that front?
No, Your Honor, we did speak with her previously and she did oppose the bond.
She did. No,
However,
I'm remembering from before. I just wasn't sure if there had been more recent contact between your office and Ms. Little.
yes, we reached out to her on yesterday, but we wasn't able to get her. We left her voicemail and text message, but we haven't been able to talk on the phone with her.
Got it. All right. Thank you so much. Mr. Wallach, anything else?
Judge, yeah, the only thing I would add is two things. One is in terms of proof. I understand what the state is saying. We haven't proved it wasn't made indirect. We can't prove that. I mean, that would essentially require us to present every female in Arizona that Mr. Williams might know to say, he didn't tell me to call. We don't know who made the call. And so we're basically in a position where we can't prove the impossible.
Well, I mean, I think it's less difficult than that. I think it's difficult, but the reason why I have not yet granted bond is because I believe, and I don't think it's a leap, that the person who made the call is someone who is close to Mr. Williams. It's not going to be a random individual who just coincidentally is from that area code. It's someone who knows Mr. Williams and his plight and feels strongly about it, and who knew Ms. Little and had some information about her. And so the way Mr. Williams gets around this is that that person steps forward and says, I did it, and it was not at the direction of Mr. Williams. And what we have is not that. We have Mr. Williams saying, I didn't do it. And we have his wife saying, I didn't do it. That's good. It would be bad news if Mr. Williams did it, because then he might have new charges and not just no bond. But I believe, I continue to believe that the perpetrator of that fraud on Ms. Little is someone close to Mr. Williams. And if that person wants to right the wrong, that person can come forward and say, I did it. And I messed up and I shouldn't have done it. And then whatever the truth is, and I did it because Mr. Williams told me to, or didn't tell me to, or his wife did, or whatever the situation is. But your job isn't quite so hard as finding every female in that area code. But it's not easy because the person who did it has probably figured out that was dumb, borderline illegal. And so I'm going to keep a lower profile, not call Ms. Little again. But that's where we are. So I will wrestle with it. You've helped me think through it a little bit more, especially with the timeline as to when the call was made and the fact that nothing has happened since then.
Well, Judge, and the only thing I would say in response is I obviously would love to be able to present that, but that would take me also knowing who it was or them doing that. And the issue really is whether to hold it against Mr. Little and continue to keep him incarcerated based on someone else's conduct.
Okay. Got it. Mr. Williams, have you followed everything we've been discussing?
Yes, sir.
Do you have any questions for me about the process? Not about the facts of your case. Those are questions for Mr. Wallach.
So when will I get a decision, sir?
So I will enter an order, if not today, then Monday, that either denies bond again or that sets bond with a host of conditions. And you won't get it directly. Mr. Wallach will, and he'll let you know what's in that order. We're also, Mr. Wallach, we're going to move, I'm going to orally deny your motion for more discovery time, given my representation to you that you are not going to be told that your evidence is excluded, that you discover a month from now, if that makes sense.
Yes, I'm comfortable with that, Judge. Thank you.
Good. That way we're moving full speed ahead. Regardless of my decision on bond, we'll be moving as we should towards a final plea date and a trial date for Mr. Williams, whether he's coming for those from Arizona or from Rice Street. Okay.
I'm sorry, can you just remind me if there's a deadline for motions that was tied to discovery, if that's coming up, just so I make sure that we're in compliance with that as well.
I'm going to look at the scheduling order right now, and if we need to amend it because I didn't rule on your motion, let's see. Oh, here's the order amending. So January 9th, I entered an order that says discovery closed. Closed is a weird word in the civil criminal side. 4 days ago, motions are due on March 9th.
Okay.
You had already filed a bunch of motions that you said, look, I don't know that I'm going to pursue these, but you gave me this first deadline. I don't want to miss it. So you've got March 9th as your new and final deadline. And I'd ask you if there are things that you had filed prophylactically that you don't want to pursue now that you've had more time to think about it, withdraw those so that when the sun sets on March 9th, we know the universe of motions that are out there. And then Ms. Nelson and I can look at them to say, all right, these are great motions. Those can be resolved on the eve of trial versus, that one requires a hearing, and we'll set a hearing date.
Okay, terrific, Judge. I appreciate it.
You bet. Ms. Smith, anything else on behalf of the state?
No, Your Honor.
Thank you so much. All right, Mr. Williams, I will let your lawyer know.
Sir, thank you.
All right. You too. Bye-bye. Mr. Aurora, appreciate your patience. I haven't seen Ms. Winfrey, and she may just be watching and seeing that we aren't done yet, but we'll need her. So, Ms. Smith, I think we've just got a couple more revocations that are either stipulated or will be rescheduled, and one bench warrant to discuss. Were you going to cover Ms. Winfrey's case?
No, I'm here, Your Honor. I will come down to the courtroom.
Okay, you got a few minutes. I just wanted, Mr. Aurora's been here along with his client and his client's supporters. I just want to make sure you were in the queue, and you are. So I'd say you probably got 10 minutes.
Okay, thanks, Judge.
You're welcome.
Judge, can I make a quick announcement on position number 9?
Sure, you beat me to it. I was going to get to Cobb, but let's do Mr. Ware. Do you want me to get him on the screen?
Yes, Judge, I see him standing up. There he is.
Yeah, I think I've seen him standing too before. Let's get him. There he is. And let's turn on his. Mr. Ware?
Yes.
Good afternoon.
Hey, how you doing?
Ms. Wood?
Thank you, Judge. So I had met with him on Wednesday, but since then, Ms. Smith and I have continued negotiating and working things out. I owe her a waiver of indictment on the new case. So I'm just asking if we could put this on one of the calendars for the first week of March to take care of this as well as the new case. And Ms. Ross was involved, and she told me that should be enough time for her to have everything squared away as well on her end.
Got it. So it would be a revocation, a plea to a green sheeted accusation, and it sounds like your office, Ms. Wood, has lined up some programming for Mr. Ware.
That's correct, Judge. And Mr. Ware, I'll be out to see you to go over everything because I know when I saw him on Wednesday, I didn't have anything solidified. But I think it'll be easier if we do it this way, Judge.
Sure. Well, and Mr. Ware, I think you may not feel like it's all that different, but if you're going to be resolving the new charges that are the basis for the revocation, if you're doing that plea at the same time as the revocation, you're guaranteed that the two sentences are you're closer to being guaranteed that the two sentences are going to be the same. Because otherwise you might end up with two different judges and they might look at things differently. So what we'll do is reset your situation to not next week, but the week after, and see if we can knock out both those things then. Does that make sense?
Yes, sir.
Okay. And have you met with Ms. Ross? Does that name ring a bell?
Yes.
Good. Okay. Then it sounds like some of the pieces are falling into place. Ms. Smith, anything on Mr. Ware's case?
No.
Sis? Okay. All right, Mr. Ware. I don't know if it will be virtual or in person. We do more stuff in person, so it may be that you're brought over here, but I will see you in the next couple of weeks either way, okay?
All right, thank you.
Bye.
Thank you, Judge. May I be excused?
Now I see why you cut in line. Yes.
Thank you. Have a great weekend.
You too. All right, I would like to do Mr. Brown now. I think he's the last gentleman in Cobb, so we can get Cobb off the hook. Mr. Brown, are you able to unmute the machine there? Boom, you did it. All right. Ms. Rios, move spotlight. You still around?
Yep.
Good. There she is. Okay. So this is a bench warrant situation. That's an old case. All right. Why don't you tell me the situation with Mr. Brown?
Yes, Your Honor. He moved. He lives with his mom now. I believe his family should be on, but they may have gotten off. But I've spoken with his family. And so we have an address for him. I did talk with the state, and she did say that she would consent to setting aside the bench warrant. We were hoping to resolve this case with diversion, but it looks like they emailed back and they probably are not taking him, but he doesn't have a history. I don't think he has like more than this FTA. And I was asking for you to set aside the bench warrant. I do have a number for the family, so I'll be able to get in touch with him.
What was it that he missed?
Plea
Plea arraignment? Okay.
Yes.
Way back in 2024, I guess so, it would have been. And so then he just sort of was out there and then the bench warrant caught up with him.
Yes, Your Honor.
Okay, got it. And I've got so his address is, there's one in Fairburn and the other one just says residentially challenged. Do we have a good address?
Yes, I believe we have a good address. I think his family's on. I think she might want to speak. Is this the person waving her hand?
The Motorola. Okay. Can you, let me see, I'll ask to unmute. Are you able to unmute Motorola?
Yes,
Hi there.
sir.
Hey, how are you connected to Mr. Brown?
My grandson.
All right. So you are grandma. Thank you for calling in.
His dad on too.
Okay. Well, thanks to dad being here as well. Where's Mr. Brown going to stay when he gets out?
His mom.
Oh, so not you and not his dad.
He couldn't get off from work.
Okay. And where is mom your daughter?
No, sir. His father is my son.
Got it. Okay. So your daughter-in-law-ish. Where does she stay?
In East Spring.
Okay. And does she have an apartment or a house?
Apartment.
Okay. Who else stays with her?
I think it's her and a cousin. I'm not sure.
Okay. But there's room for your grandson there?
Yeah. He used to stay with his mom before.
Okay. All right. Mr. Brown, do you know where it is you're going to be staying?
Yes, I do.
Okay. And where's that?
4085 Washington Road.
That's your mom's apartment?
Yes.
Okay. Are you waving to your grandson or do you have more you want to say?
I want to talk to you, Joanna. I want to, cause he have a good job that's waiting on him, to keep him focused and stuff, but it's not, but he got picked up, but it's not even here. It's been, they hired people from Georgia and took him out there to work
Where?
in Texas.
Oh, so I don't know that he can go to Texas while he's on bond.
I just asked, but he'll
Okay.
be back. I just asked, just wanted to know.
Okay, no, it's a great idea. And maybe when he sorts this case out, Texas would be a great place to go, but he's going to need to stay local till we sort this out. All right. Do you have anything else, Ms. Rios?
No, Your Honor.
Okay. Ms. Smith, anything you want to add about Mr. Brown's case?
No, Your Honor, I have an offer to Ms. Rio soon.
Okay. Let me look at the original bond. Oh, it's an old bond. Let's see. Okay. I'm gonna, add a condition to your bond, Mr. Brown, that you live at your mother's address. So Ms. Rios, I'm going to need you to email that address to Ms. Nelson so it can get on the bond. Okay?
Yes, sir. Thank you.
All right. Mr. Brown, you have any questions?
Yes. When will I be getting released?
Monday or Tuesday?
Thank you.
Okay. And then when you are released, you need to go to your mom's. You're not going to have a curfew, but that's where you need to be spending your nights. Okay.
Yes, sir.
All right. Let me see if there's anything else in the bond. Nope. That's it. Okay. Then we're all done. Thanks for staying on, Grandma.
Okay, thank you so much, Joanna.
Take care.
You too.
Am I done?
You're done.
Okay, thank you.
Bye.
Your Honor, at South Annex, we're having difficulties with their logging on. They should be on shortly.
Okay. Thanks for the update.
No problem.
I think that's all we have left. Did I miss anyone? That's Mr. Slade. Did you have anything else, Ms. Rios?
Position 5.
Position 5. Oh, right. Price. No, that's
Yeah,
the
that's
South
what we want.
Annex.
Yeah, I
So
don't
it's-
think we did everything.
Where is Slade? I haven't seen him
Oh,
on
wait,
any.
yeah, it's Slade.
He's at South Annex also.
Oh, so we got 2 at South Annex. So we're waiting on them.
Yes, sir.
And I do believe Miss Simpson was going to ask for a reset on him.
Ms. Simpson's going to ask for a reset. Why
Yes,
is that?
Judge, he has 2 open cases that the officer did not include on the petition.
Oh, okay. And what were we going to do with Price? Because what we may do then is just bump them to another calendar since we're having technical difficulties with South Annex.
Price was a bond hearing, and I believe he had a family member on, but I'm not sure if they're still on there.
I didn't have it as a bond hearing. I'm sorry.
Oh, I did. I'm pretty sure I filed a bond motion.
All right, calendar doesn't say that. It doesn't mean that someone didn't talk about that, but if the state wasn't on notice, then we would need to give them a reset anyway to contact the victim. Let me look here. You filed your motion on the 20th, a month ago, so it's 1 month ago, but doesn't say bond on the calendar. That may be a process we need to tighten up where Ms. Rios, you or Ms. Wood let Ms. Nelson know, hey, there's this motion as well. It's not her job to catch all the motions as they come in. We need to have them flagged. Hey, could you include this along with plea and arraignment? And you may have done that, but we need to make sure that that happens. So what I'm going to do is make the executive decision because I have a plea that was supposed to start at 3:30 and here we are almost 4:15, is that we will reset position 5 for a bond hearing. Now the state knows when Mr. Price is back, it'll be a bond hearing. And we have to reset number 8 anyway for the probation officer to get a more complete petition put together. And then we will handle both those. And we'll expedite Mr. Price's situation and put it, since he's in custody anyway, sort of next available calendar. Mr. Slades doesn't need to move quite as quickly. It sounds like his life's just getting more complicated with the more comprehensive petition. Does that work for you, Ms. Rios?
Yes, Your Honor.
Okay. So I'll make those notes, and I think that covers all the folks that we had. So, Ms. Reynolds, thank you. We're going to pass on South Annex today, and appreciate you lining everyone else up in all the booths.
No problem. Y'all have a good day.
You too.
Bye.
Bye. And Ms. Stallworth, I'm going to get you out of here real quickly. We are going to get on the record in a minute for our plea, which is Mr. Winslow. Did you get that calendar?
I did not, Your Honor.
Okay, what information do you need from me to run his history, which I think you're gonna learn has nothing in it, but I need to confirm that.
I just need his full name and case number.
Okay, first name is Christopher. Middle name is James. Last name is Winslow, Winslow. Case number 25, SC 002-678.
Okay, thank you.
All right. Thank you. And you should just sort of barge in once you've got that info, because I think we'll get rolling with the plea in just a moment. I don't mean for you to stick around for all of it once you get that info.
Okay, yes, sir.
Thanks, Ms. Smith.
Thank you.
So then we're back in my office. I'll be back to start on another matter.
You're free to come and go. I need 2 minutes. I've been out here since 1, so I'm gonna take a quick break. And then we will, all that's left is Mr. Winslow's case for today.
Probably, but I have the answer. Just gonna do it. Yeah, this is the finals. It's just, he asked specifically about types of files, number of files. I have that information.
Looked at the police, it's like 250, like where they burn files or just.
There were files. Mhm.
Merci di quoi comme rôle.
I'm ready, Your Honor, whenever you are.
Oh, okay, thank you. What'd you find?
He doesn't have anything outside of this arrest.
Okay, thank you, and thank you for filling in today. I appreciate your time. You have a great weekend.
You're welcome. You too. Thank you.
Bye. All right. Ms. Rivers, you still with us?
Yes, I am.
Great. Let's get on the record in Mr. Winslow's case. It's 25 SC 002-678. It is State versus Winslow. Mr. Winslow is represented by Mr. Aurora. He is here with his client. Ms. Winfrey is here for the state. And we are going to handle a plea hearing. Is it a negotiated or non-negotiated plea?
It is negotiated.
It is negotiated. So the sentence that you shared in your sentencing memorandum is the negotiated sentence.
Yes, I also put that in the email that I sent you. Yes, it's.
Okay, it may have said, I just didn't know if it was negotiated, but now I know. Okay. Mr. Winslow, good afternoon.
Good afternoon, sir.
The way this is going to work is that in a moment, Ms. Winfrey is going to put you under oath. Once you are under oath, you'll need to answer all her questions and mine truthfully and completely. If you have any questions of your own, you should let me or Mr. Aurora know about those questions so that we can answer them either on the record, if it's appropriate for me and Ms. Winfrey to be involved. If you need to confer privately with Mr. Aurora, that's easy to do. We'll just have you step back from the podium, maybe even step out of the courtroom. I don't know that you'll need to do any of those things, other than that you do need to let me know if you've got a question about something. Will you do that?
Yes, Your Honor.
Okay. Ms. Winfrey, when you're ready.
Thank you, Your Honor. Will you please raise your right hand? Do you swear or affirm the testimony you are about to give in the matter pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
You may put your hand down. Please state your true, correct, and legal name.
Christopher James Winslow.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
Is there a medication that you normally take that you've not been given today?
No.
How old are you and how far did you go in school?
I'm 67 years old, master's degree.
In what?
A business.
Like MBA?
Yes, sir.
Where'd you get your MBA?
Wesley College in Cambridge, Massachusetts.
Okay.
The judge is also familiar with Cambridge.
Okay.
So are you able to read, write, and understand the English language?
Yes.
Do you understand you are charged with the following offenses? Counts 1 and 2 are sexual exploitation of a minor. Counts 3, 4, 5, 6, 7, 8, 9, and 10 are possession or control of any material depicting a minor in sexually explicit conduct. Count 11 and count 12 are theft by conversion counts, and count 13 is a false statement in indictment number 25 SC 002678. Do you understand that's what you're being charged with?
Yes, ma'am.
And do you understand that you have a right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
And do you understand that, let me ask you this question, excuse me. Have you reviewed the waiver of rights form that I'm holding up with your attorney?
Yes, I have.
And the plea of guilty?
Yes.
And is this your signature on the last page of this document?
Yes.
And Mr. Aurora, you signed this document as well?
Yes.
And
Can
you
I just want to see, it's a funny looking.
The fonts are a bit off, Judge, but the questions are all there.
Okay.
For some reason, the style got.
Yeah, it's just different. But it covers all the important stuff. Okay. I'm gonna keep this. Is that all right?
Yes,
Okay.
Judge, thank you.
All right.
Have you had enough time to speak with your attorney, Mr. Aurora, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
And do you need more time to discuss this case with your attorney?
No, I do not.
And are you satisfied with his services?
Yes.
Counsel, do you waive formal reading of the indictment?
Yes.
Do you waive any and all defects in the indictment?
Yes.
Mr. Winslow, has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to today?
Yes.
I guess for purposes of the record, I want to just go over that. Counts 1 through 10 have the same exposure. The minimum sentence is 5 years. The maximum sentence is 20 years. Counts 11, 12, and 13 have the same exposure as well. The minimum sentence is 1 year. The maximum is 5 years for each of those counts. Do you understand that?
Yes.
And do you understand that this is a negotiated plea of guilty,
which means that the state will make a recommendation and along with your counsel, a joint recommendation to the court, but the court does not have to accept that recommendation. The court can sentence you to the maximum on each charge and can run those charges consecutively, which means one after the other.
Yes.
And do you understand that neither the court nor the district attorney's office has anything to do with parole or the Department of Corrections or boards of pardons and paroles, and no one can guarantee parole?
Yes.
And do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes.
And do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
And do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws or any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence?
Yes.
And do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
And do you understand that you are pleading guilty to a crime against a minor in this case, and you will be required to register as a sex offender?
Yes.
And do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at a trial would? This is true regardless of any advice given to you by your attorney or anyone else.
Yes.
And do you understand that do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain or even maintain employment.
Yes.
And do you understand that by pleading guilty to a felony, if you use, receive, or possess a firearm or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes.
6. Sorry. Do you understand that you waive any and all defenses, including any mental health defenses, by entering your plea of guilty today?
Yes.
And do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or remain silent and not incriminate yourself?
Yes.
And do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after trial. Do you understand you're giving up all of these rights?
Yes.
Has anyone forced, threatened, or promised you anything to get you into a plea of guilty?
No.
Is it your decision then to waive your rights and enter your plea of guilty because you are in fact guilty?
Yes.
So how do you plead to the charges in indictment number 25 SC 002678?
Yes. Guilty.
Is this guilty plea freely and voluntarily given with a full knowledge of the charges against you?
Yes.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
And do you understand that you have 30 days from the date the sentence is entered to file a direct appeal?
Yes.
And do you understand that you have 4 years from today to file what's called a habeas corpus petition challenging the voluntariness of your guilty plea?
Yes.
Your Honor, as you already know, the defendant's criminal history is no criminal history except for the current case, the arrest in this case. Had this case gone to trial, the state would have proven that this case generated from Sandy Springs Police Department under a cyber tip from the National Center of Missing and Exploited Children. So on March 28th of 2023, the lead detective in Sandy Springs in this case received a cyber tip. Based on this cyber tip, the address came back to a internet service provider, Yahoo Inc. They provided the cyber tip to NCMEC. The email account associated with it was Maxim, MAXIMUSBABA @yahoo.com.
Upon research of that email address, they determined the IP address associated with that email account. It came back to AT&T, which came back to 6721 Castleton Drive in Sandy Springs in Fulton County, and that's associated with the defendant's email also as cjameswinslow@outlook.com. So once the detective received that NCMEC tip and the previously mentioned email address, the maximbaba@yahoo account, they confirmed that there was 5 images that contain CSAM, which one is charged in count 1 of the indictment. After confirming that the CSAM had been shared with the person residing at the 6721 Castleton Drive in Sandy Springs, they confirmed that the phone number associated with that account also belonged to the defendant. Search warrants were obtained for the Yahoo account. Search warrants were also obtained for the Verizon account to make sure that was confirmed. Then, in April of 2023, detectives received 2 additional cyber tips from the Georgia Bureau of Investigation, and they investigated those 2 cyber tips. During that investigation, they learned that the defendant was an employee of Mount Vernon School as their chief financial operating officer. And so based on the 2 additional cyber tips they received that were associated with an Apple account and was associated with cjameswinslow@icloud.com, they also determined another email account, the same email account associated with the earlier cyber tip. So you have 3 cyber tips all associated with this defendant. They also discovered that their emails were going back and forth from the cjameswinslow@outlook account with a signature line on the bottom that said Christopher Winslow, Chief Financial and Operation Officer with the Mount Vernon School that's located in Atlanta. Detectives also determined that there were uploads beginning like April 7th of 2023 from that same IP address from the initial cyber tip. The detectives then, as they were looking into all 3 cyber tips, they discovered that there were images of a prepubescent female child with brown hair and 2 pigtails. She's wearing knee-high blue socks and a nude with her knees up, exposing her vagina to the camera. That is count 2 of the indictment. Again, these are sharing opportunities that the defendant had. Based on the review of that cyber tip, the second cyber tip, they also discovered, again, the accused defendant's work signature at the bottom of those emails. It was further noted that these emails were going back and forth with other people who were they were requesting and then providing the images. All of these email threads discuss sharing pictures and videos with one another. Detectives determined that the accused was an active participant in these exchanges of the emails. It was further determined that the defendant was actually seeking out emails as well on an account called Mega Application. It's a Russian-based website that provides the service of sharing content, but not subject to legal service or search warrants. So then on April 27th, a search warrant was executed at the defendant's residence, April 27th of 2023. And based upon that search of the defendant's residence, they found 4 phones, 13 USB hard drives, 5 computers, iPads, tablets were seized. And then they got another search warrant to go into the devices. It's important to note for purposes of this plea that once the defendant was arrested, he was cooperative with law enforcement and admitted to his identity with the email addresses that matched the cyber tips that were received by the investigator. He stated that no one else had access to his phone, that he was the only one that used the phone. He disclosed that the phone was registered to his employer. He stated that only he and his wife lived at the residence. He admitted to having the numerous email accounts to include the Yahoo accounts subject to this case. He also stated that the laptop belonged to his employer. He admitted to being on the Russian website that I've just discussed. He also admitted to opening up that Maximus Baba Yahoo account. He further disclosed that he opened them about 6 months prior to the interview and his arrest. He admitted to receiving photographs of younger children, ages 11 to 12. He admitted to battling addiction for the last 5 to 7 years, and he further admitted that he's tried to stop and that it was a huge mistake. During the interview process and in waiving his rights, he did lie about not having any content on anything. And once the devices were obtained, that was not true. It was determined that, now he had thousands of images. Some were pornography, some were child erotica, and then there were lots that were also CSAM. So we determined there was 253 pieces that were tagged as CSAM that contained depictions of female children exposing their female sex organ or engaged in masturbation in the camera. Those items were tagged and they are charged in the indictment. We did not, however, charge Mr. Winslow with 250 some odd counts of child sexual abuse material, I think primarily because of his cooperation with the investigation and him not having any criminal history or history of any sexual deviance. We also discovered that the iPhone 11 Pro that was used, that was belonging to Mount Vernon School, that he did knowingly convert that property for his own use in violation of the agreement in his employee handbook that he signed on August 9, 2021 about the use of it, the value being more than $1,500 but less than $5,000. Same thing with the Dell laptop that he converted it and used it. He visited a site called Chatterbait, which is actually a site where there's a live webcam where you can watch people masturbating, which the property belonged to the school, which goes to theft by conversion. The 2 theft by conversion counts in the case. The school did issue, they didn't want to be a part of this plea hearing. They issued a letter early on in the case to their students. There had been no evidence that Mr. Winslow had any hands-on offenses or anybody made any outcry that anything had been done with the child at the school, but the school did not want to participate in this hearing and didn't care anything about any kind of restitution as it relates to the devices that they owned. So we did talk about that. And kind of answering some of the court's questions that you sent earlier, all, if not most of the CSAM was found on a terabyte drive, or there are several thumb drives that were obtained. And it appears that it had 2 separate folders. And on those folders, he kept maybe CSAM on some and pornography on another.
When you say pornography, meaning adults?
Correct.
Okay.
Like, or questionable ones where we couldn't determine if
Could be a 16-year-old, could be a 13-year-old.
Could be an 18-year-old.
Right.
So there were hundreds of photos and videos of CSAMs in these folders. Some of the pictures and videos in these folders were not charged, as I just stated. The files can go back to like count 4. That file was created in 2013, but it was been on his hard drive since 2016. And of course, when we got the devices, it was in 2023. So we charged the date of possession, of course, when we obtained those devices on the day that he had them. So he's had like count 6, most of them. He either created the file was created in 2017, but on his hard drive since 2018. So in terms of date range and how long he's been involved with this type of behavior, he did admit to being involved with this kind of behavior at least 5 to 6 years, which corroborates what we found on his device in terms of determining how long the images had been on his device. We are asking the court to consider, and for the record, the state did receive the psychosexual that Mr. Winslow had done by Medlin Treatment Center and considered that as well in terms of the sentencing that we're requesting. So in this case, Your Honor, we are requesting a global sentence of 15 years to serve 3 years with the balance on probation as to each count and that they run concurrent with one another. We are also asking that Mr. Winslow, and we have comply with the sex offender treatment conditions, general conditions of probation, the restrictions of computer use as outlined by the Department of Community Supervision, mandatory submission of polygraph, and there is a Where's the other one here? There's a GPS monitoring requirement, and I have all the forms for the court to consider that Mr. Winslow has signed off on with his
Okay.
attorney, that we would ask as special conditions. We also asked that he stay away from Mount Hermon School, that he not be around any children under the age, of course, under the age of 18, that he follow actually the recommendations outlined in his own psychosexual. There are several. We asked that he follow those recommendations, and that would be the state's case.
All right. So the first two counts are different from the next 8. It's not all possession. The first two strike me as, I think what we would have called on the federal side is publishing. So you're making it available for someone else to get. It's sort of like a gas station. Someone can come and get it. You're not pushing it out, but it's available. If I were to go to whatever collection Mr. Winslow had, I could get the image that you described in count 1 and count 2. Is that a fair description of what he was doing?
That is a fair description, but to be clear, he was also sending images through the emails.
Okay.
Which is how you got the hit from Yahoo.
Okay. So at least one of the cyber tips was because it wasn't passive distribution, as in a gas station. You can come to my station, and if you want to download, you can. It was active distribution in that there was evidence of Mr. Winslow saying, here is something, whether you asked for it or we're trading, I'm going to send you something, you send me something back. He was actually delivering it as opposed to letting someone come get it.
That's correct.
Okay. And so that's counts 1 and 2. And then 3 through 10 reflect images, videos that were in his possession, but you're not alleging that those are things that he was trafficking to other people.
That's correct.
Okay, and then I didn't realize the theft by conversion, you covered it, but that's the school phone and the school computer using them for these illicit purposes.
Correct.
And then finally, the false statements is you told the police there's not going to be material on this device, or I didn't share, whatever it was, and that proved to be, he was very cooperative, but there was something he said after he'd been Mirandized that was materially false.
Correct.
Okay, got it. Thank you.
Thank you.
And we've heard about criminal history, none, which means then, Mr. Aurora, I can turn to you for you to share what you want to share. And I have read your materials. That doesn't mean you can't talk about them, but I appreciate always getting that stuff in advance, because when I have a chance, I try to look at it so that I come prepared.
Right. So the reason I mentioned the 253 photos that DA mentioned is I did a whole table on as much discovery as we had on there. And a lot of it, I can't look at all the CSAM and cross-reference it. So it gave the impression then that a lot of it wasn't CSAM, but I don't know, I'll defer to them, but we tried to go through it line by line with what we had. And so I think there were 253 photos, and then 2 of the 15 hard drives actually had some pornography, some adult, and then 1 had some other stuff in it. But it was in 2 folders, but they weren't like young, sexy brown girls or anything. It was just random folders. So when you and I think about organization, this stuff, it's not like this type of that type. It was just stuff that was dumped there, and it was just sitting there and probably hadn't been open in a while, but he had it for several.
He had collected it and he put it in one place, but it's not the scary collections where it's little boy being hurt, little girl with dog. I mean, that they're literally, hey, if I look in, I know what's in this folder because it's descriptive and there is value to the collector of putting it in different categories.
This is just like how your iPhone photos would just sort of go down into whatever folder, albums or whatever it is. There wasn't anything specific, at least that I saw.
Okay, not my iPhone photos, maybe your iPhone photos.
I learned that from the last time we talked.
Yeah.
Also, with regards to the sharing, the first 2 counts are based on sharing. He didn't just have an open portal and said, hey, come get it, I'm doing whatever. You'll see that there was a couple of talks between 1 or 2 other people as far as that goes, and that's why it was a distribution that they exchanged a photo or a video. That's why there's 2 counts, not more than that as far as that goes. I've given Your Honor the information from the psychosexual. He also, we went to Midland because of time constraints. We didn't know how fast the case was going to move back then because Highland Institute was backed up. But we did go to Highland to get counseling for months and months and months, as I put in the paperwork to you. I don't need to reiterate it. We've tried to make amends the best that we can. His entire family is here, and arguably going to jail is horrible, but facing your family and explaining to them after all these years and your kids that are here, this is what I've done, was tough. I know I fought with the prosecutor a little bit about it being, it's petty to say, you know, hey, I used my work computer for personal purposes, therefore I stole it, so we'd all be in trouble. And then initially, shockingly, he denied, you know, the pornography, but it's a 3-hour interview and he went through all of it afterwards, so.
It crumbles in the end, but there's often, there's nothing on here that's problematic. You can look and maybe they won't find it until
Right.
they find it.
And most of the stuff, it wasn't like on the dark web stuff. I mean, he had 2 other emails, but it was all connected back to his own name, his own phone number, all that, and just
Right.
like I've explained to you in other cases, not rocket science like those creators on the dark web doing things. It's just, it was a addiction, as he told the police officers, and we've spent 3 years going through counseling, and thankfully his family's still with him on this. He understands the consequences. The only other thing we'd negotiated is that he'd be allowed to have 2 weeks to turn himself in, which would be.
I was going to ask about that. And yes, you agree a delayed turn in, or you are saying I'll leave it to the court, or what's your perspective?
So initially, I think.
I'd ask till the
After 3
13th,
weeks,
the
yeah,
trial date.
I said no, he said 2 weeks. I said, well, yeah, I'll leave it to the court to decide.
Okay. Because in some ways it's been 3 years. And in other ways it's final and it won't be today. So deep breath. Okay.
And so I'm trying to get their powers of attorneys and everything done, and you can say, well, why don't you do it this way? But unless you're in that position where you're not thinking, it's like now all the realities.
It brings focus.
Yes. And so I'm going to be in South Carolina on 2 cases next week, but I've got to get the power of attorneys, healthcare stuff for his wife and his kids set up. The only other thing I have is his son would like to make a statement to you. You've got his statement.
I've read it.
I'll admit those, and then if you could do the Medellin report just for the record under seal, in case anybody wants to.
So Medellin under seal, the others can just be part of the record. Okay.
His statement.
Sure. And you've seen all these?
I've seen them.
Okay.
Thank you.
So it's just the medical stuff.
Yep. No, and we did it with Mr. LaChapelle. Is that the name?
Yes.
No, you didn't do that.
I didn't do that one, but it's in my unit. Your Honor.
Yes, it is. All right, let me just make sure this says under seal.
And if Your Honor wants to do the allocution with him, that's fine, and then I'll have his son speak on behalf of the.
No, I'm going to let Mr. Winslow go last unless he wants his son to go last. I prefer to turn to, you tell me, you're going to have an opportunity to say anything if you want to. You don't have to say anything. I usually reserve that till the very end. And then we have our conversation about sentencing, et cetera. If there's a reason why you want your son to go second, it's your sentencing and not mine. So I'll let you decide that.
Is it okay if my son please goes?
Sure.
Is that
Yep.
okay?
Yeah, that's.
He'd like you to go first.
And I don't think he'll have much to add. That's why you wrote it all down, because people get nervous at this point. That's
Sure. Or they have their lawyer read it or someone else. So they're 2 guys. I don't know their son. Okay.
You scoot your way and you can talk in the mic.
Good afternoon.
Afternoon.
Can I have your name?
Christopher Gilman Winslow.
All right. Mr. Winslow, number 2, why don't you share with me what you want to share?
I would like to thank the court for allowing me to speak on behalf of my family for my father. My father is not a perfect person. Like all of us, he has made mistakes. However, my father is a loving, generous, kind, supportive, and caring person. He has dedicated his life to his family, and we are forever grateful. For nearly 3 years, my father has been cooperative and actively making an effort towards rehabilitation, displaying an intense determination to seek help and to better himself. Between therapy, support groups, daily reflection, and prayer, nothing is more important to him than personal growth and his family. I can say with no hesitation, he is deeply hurt and apologetic for the circumstances that bring us here today. And he has dedicated every waking moment of every day to regretting his mistake and improving himself and the circumstances of his family. I would also like to bring attention to the fact that my father has never been in any legal trouble and that the accusations against him are nonviolent. He was transferred from Fulton County Jail to Atlanta City Detention Center for his cooperative and harmonious demeanor during his time in jail before being released. My father is not a violent or combative individual, and we believe this, his ultimate and successful rehabilitation and safety, needs to be taken into consideration beyond what happens today. My father is 67 years old, my mother is 72 years old, and although my sister, her husband, and I live close and will be able to give our time and support, she will still live alone with their adopted senior dog should our father serve a sentence from the state. Our ultimate hope as a first-time offender is that he would not need to be separated from his family because we feel the rehabilitation and support he will receive from counseling programs and from us will be more effective and safer, particularly for an elder person. However, we respect the court's decision and will continue to love and support him and pray for his safety during any time he may be away from us. On a personal note, I have struggled with substance abuse issues on and off alcohol over the past 5 years. I have been to detox, rehab, and the ICU on more than one occasion. The support of my family, but particularly the support of my father, has been paramount to recovery. Both times I opened my eyes after being admitted to the hospital, my dad was the first face I saw. He was there every day to talk with me and support me, being caring, firm, supportive, loving, and being the parent and best friend he always has been. Nothing that has happened has changed or will ever change the love that we have for him. We continue to support him as much and more than he has done for us throughout our lives. We humbly ask that you take our family's love and support into consideration with regards to sentencing. I thank you again for allowing me to speak on behalf of my family.
You're very welcome, and I appreciate you sharing that, and good luck with your recovery.
Thank you.
I don't have anything else to present, Your Honor.
All right, but thank you again for you actually had plenty to present. You got some of it to me in advance, and it's been thorough as it usually is. Mr. Winslow, if there's anything you want to add, you may. You don't have to say anything at all. I've read your letter, so you've already shared some things with me and with Ms. Winfrey, but I'm happy to hear more if there's anything else.
I appreciate you letting my son talk.
Sure.
I appreciate my family. Thank you.
Okay.
Thank you, Honor.
All right. Well, Mr. Winslow, I appreciate the steps you've taken to address your addiction. I appreciate your family's characterization of the situation as one with someone with no history, and these are nonviolent crimes. There's a different perspective on that as well. The no history is you haven't been arrested before, but in theory, you committed a crime every image you downloaded. And that is many images over many weeks and months. So it's one arrest in connection with a series of crimes. And while I hope that the truth is you never put your hands on a little kid, what you were consuming, what you were sharing, what you were procuring was exceedingly violent. I don't need to describe what the images were, but it is, by every legal definition, a crime of violence when an adult does something like that to a child. That's not you doing it, it's someone else, but there is the infection of violence in the world of CSAM collectors, because that's what those images are. They're violent, they're degrading, and we re-victimize those kids every time those images are transferred to someone else. And I say these tough words not to be condemning you. You've done what you've done, you have owned it, you've shared that truth with your family, and you're reconciling with them. But I don't want people leaving here saying, well, I was in court all afternoon and there's someone who hit someone else with a 2x4 and the judge didn't seem very upset with him and he's sending my dad, my husband off to prison. We need to never minimize the significance of the impact of CSAM on the children who are in it. As long as there are consumers, there is a marketplace for it and more will be made. And you were a consumer and you were a purveyor. And that means whether you mean it or not, there are more victims out there. And that's why we take it so seriously. You are in a relatively low risk category because you are older now. But as someone who prosecuted CSAM offenses for a decade, I saw firsthand people graduate from, I just look at the images, to I just touched her a little bit. And that's what we need to guard against. And that's why there are, I believe appropriately, fairly severe penalties associated with getting into the field of having a predilection for looking at pictures of 6-year-old girls having adult men doing things to them. And we can't take that lightly because of the consequences it can have. And that's why we're handling this the way that the state has insisted and the way I agree. I think that your lawyer has negotiated a very reasonable sentence for you. It is a firm sentence, but appropriately so, given what was involved. I've seen worse collections. I've seen less bad collections. Mr. Aurora's other client who was here, and you're very different people in different situations, but it was 15 images that seemed almost to have been collected by happenstance, as in you're sort of surfing the web. And you moved past that. This was clearly an intentional collection, and it was something in distinction with the other gentleman that you were then sharing with others. And that puts you squarely in the category of red alert, or what else is going on in this person's life. I trust your family has surrounded you with love and support, and that may help you navigate this going forward in a way that is safe for you and safe for those that are around you. But I encourage your family to lift you up in the coming weeks before you turn yourself in. Those are going to be difficult times. There were defendants in cases that I dealt with who took matters into their own hands and didn't have to deal with a sentence. They imposed the ultimate sentence on themselves. You shouldn't do that. And you need your family to help you be safe and thoughtful over the coming weeks before you come back here. So, Mr. Winslow, I find there's a factual basis for your plea, and that your plea is knowing and voluntary, meaning if this had gone to trial, the state could have proven definitely the serious counts, the CSAM counts. I'm with Mr. Aurora. I don't know what a jury would do with claiming you stole the laptop, but it's a creative charge. It's really a minor charge compared to the CSAM offenses. And I say knowing and voluntary, you clearly are a educated individual. You have an expert counsel. You're not going into this without your eyes wide open and having been well informed about your options, going to trial, taking a plea. So I do find that your plea is knowing and that it is a decision you've made of your own free will as counseled by your lawyer and by your family. Mr. Aurora, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Winfrey?
Yes, Your Honor.
And Mr. Winslow, can we sign your name electronically to the indictment indicating your guilty plea?
Yes, Your Honor.
Okay. You understand that as a result of this plea, you'll be required to register as a sex offender.
Yes, Your Honor.
You are now reaching the age where, if you are financially able to, you can enjoy retirement. So it may not have a big impact on your work, but it would have an impact on where you can live going forward. There are limitations on how close you can live to a park or a school, things like that. And I trust you and Mr. Aurora have talked about that.
Yes, Your Honor.
Okay. Are you working now?
No, Your Honor.
Okay. This was back in April of 23 when the police executed the search warrant. Have you worked from 23 until now?
No, Your Honor.
Okay. All right. Well, Mr. Winslow, I'm going to follow the joint recommendation and I'll break out the sentence individually in a minute, but I want to talk about the delayed report and give you a specific date because you need to understand what happens if you aren't here on the date and time that we're about to agree to. So today's the 20th. My proposal is that you come here on Monday, March 9th. So it's 2 weeks plus a weekend that you would report at 9 a.m. on Monday, March 9th. I'm happy to do March 6th, that Friday, but why not give you that extra weekend? Does that work?
Here, you want me to take?
No, it's here. You cannot just report to the jail. You actually come here to courtroom 8D. I have court at 9 a.m. So I'm going to be sitting right here. And you need to be here by 9 a.m. Don't dress like that. Dress in, if it's cold, wear a sweatshirt, but just sweatshirt and jeans. Don't bring belongings with you. Bring your glasses, but that's all you need to do. And be here. If you are not here, I will sign a different sentence. And it's a sentence of 15 years to serve 10. Okay?
Yes, Your Honor.
So you will triple plus the custodial part of your sentence if you are not here at 9 a.m. on Monday the 9th. Things happen. If you can't because you're trying, your car is broken, you let Mr. Aurora know. He knows how to reach my staff and he will guide you into court. He will say, all right, he's now on 75 South. He's coming. Okay, but that's not the day to be late because we will all be worried that you made a different decision and you're off to Costa Rica. I don't advise that, but just know that if it's 9:10, I haven't heard from Mr. Aurora, and we'll reach out to him. Say, hey, where's Mr. Winslow? And if he says, I don't know, then I sign a different sentence. And it's 15 years to serve 10 years. That might mean that you pass away while you're in custody, and that's not how people want things to end. So let's be here at 9 a.m. on March 9th. Okay?
Yes, Your Honor.
Excellent. So your sentence as to counts 1 through 10 is 15 years to serve 3 years with a balance probated. They'll all run concurrently with each other. Counts 11 and 12 are both 3 years to serve. Those are the theft by conversions. And then the final, is false statements a felony or a misdemeanor?
It is a felony.
Okay, that's 3 years to serve also. So they all run concurrently with each other. So the total sentence is 15 years to serve 3, exactly what your lawyer negotiated, but I have to give an individual sentence for each count. 3 years in custody followed by 12 years on probation. It'll be a special condition of your probation that you stay away from the Mount Vernon school. And then all the other conditions flow from the registry. I don't need to pronounce them because they're documents you've already signed, but all the requirements of the registry you'll need to follow, and that's part of your probation. These are parolable offenses. Given your criminal history and your age, you may well get paroled out. That's not a decision that I control. It's not anything Mr. Aurora controls. You control it the most of anyone by staying out of trouble while you're in custody. I don't think you're the kind of person who's going to make trouble while you're in custody, but just so you understand the process, it is an independent body, pardons and paroles. They'll look at the nature of your offense, your criminal history, which is 0, and how you've been doing in custody. And I suspect you'll be in the A+ category there. So it may be that you are home sooner than you think. And the good news for you is that home is still there. We get people standing right there who it's a dark on either direction. They're in, they're out, and neither one is a particularly happy situation. But you have folks who have stuck with you despite this awful situation in which you put yourself and in which you put them. And for that, you should be very, very grateful because that rock will be there while you're away from them and when you get back. Mr. Aurora, anything else on behalf of your client?
Just so the record's clear, Judge, because I don't always know if the jail gets it right. We have 61 days in credit from April 27th of 2023. He was arrested on just a couple of counts, released on April 29th, so that's 3 days. Then, of course, they rearrested him when they did that from 5/30/2023 until July 26, 2023. So it totals up 61 days.
Okay. Was that all in Fulton County?
It was all in Fulton County.
Okay. There should be an affidavit that the sheriff prepares that shows all those dates. You're entitled to credit for all of that. The appellate courts have been telling trial judges more and more to stay out of the business of saying, here's what you get credit for. But I can tell you statutorily, you get credit for all those days. Don't panic if you make landfall at Jackson. That'll be the facility you report to initially. And they say, all right, you have no credit because you have those days. And if they persist in telling you you don't, you let Mr. Aurora know and I'll sign whatever I have to sign to say, actually, there are these Fulton days. But we've been told to stay out of that. It's the custodian, sheriff, who transmits that information to the Department of Corrections. But you are certainly entitled, and I'm making it clear on the record, to each one of those days. And they matter.
And one other thing, Your Honor, if we could have unsupervised contact with people under 18 because of his family members, that would be the supervised contact, I'm sorry, I said unsupervised.
Okay.
Folks under 18 versus no contact, which is what the...
So you should have no contact with minors who are not part of your extended family. So if you're in a McDonald's and there's a 6-year-old, you don't go over and say, hey, how you doing? If you have a nephew or a niece or a grandson, as long as there is another adult in the space, it is okay for you to be in that space. So you may have supervised contact with minors who are family members. Otherwise, it's the standard rules for anyone who's registering as a sex offender. Ms. Winfrey, did you have anything else for the state?
No, Your Honor.
Okay. Any questions, Mr. Winslow? I don't want you to be confused about anything we talked about.
No, Your Honor.
When will I see you next?
March 9th at 9 a.m.
It's my mom's birthday. Be there on that day, okay? Don't disappoint her.
Yes, sir.
All right. She's older than you. All right. Thank you, everyone.
Thank you, Judge.
Judge,
Hold on. Yes.
could you ask Mr. Winslow if he could give me a call?
Sure. Does he have your number?
No, I can give it on the record if that's not a problem.
I will write your number down on a little note card if you want to, if you don't mind saying it, you can say it. Otherwise, you can just send it to me via chat and I'll give it to him.
I'll send it in the chat, Judge. Thank you.
Okay. Ms. Simpson is with probation, so you know where that voice came from. She is the probation person assigned to my division, and she's going to talk to you probably about some of these conditions and your reporting instructions, which you don't need to worry about for a minute. But with cases like yours, I think DCS, that's her division, department, they try to make contact early on saying how things are going to work. So let me see. There's her number. Okay. So if you'll just sit tight, I'm gonna write that down and I'll get that to you.
Thank you, Adam.
Okay. Anything else from anyone on the Zoom? No? Okay. It's after 5 on a Friday. Thank you, Ms. Rivers. Welcome.
Okay, Judge, have a good weekend.
All right. Oh, we're picking a jury on Monday, so you'll be here?
Yes, I'll be there.
Yay. Happy